appeal in the matter of Rexhaj and the Secretary of State for the Home Department. Good morning, my lords. She said nervously.
Yeah, you needn't, because these are things that we asked for, so it's our own fault if
Well, your lordships were quite right to ask for them. Can I explain what's in there? So there is a supplementary legislation bundle that I'm going to speak to, which answers some of both your lordship's questions and my Lord Justice Lewis's questions, and some points that were made in oral submissions. Then what I have provided separately, because I think your lordships will want to put it in the bin, is HC 813. The reason that your lordships will want to put it in the bin is because the court will see that all it does is insert new appendices, so it doesn't really help the court. So I've extracted...
Yes, I see, but it's still useful to see how it's done. I agree. I agree we won't be turning every page.
Perhaps your lordships won't put it in the bin, but anyway, it's there. But I didn't put it in the bundle because...
No, well, your decision not to put it in the bundle probably vindicated, but still, I'm not displeased to have it.
And then finally, I understand my learned friend Mr. Metzer is going to rely on an explanatory memorandum which has been handed up separately to the original immigration rules that came into effect on the 30th of March 2019.
Yeah. Well, obviously up to you whether you try and anticipate what you think to say about it or leave it to reply.
No, I'm going to leave that to a reply if I need to.
Yeah.
So with that, this is how I propose to deal with matters today. Taking the easiest thing first is to answer the question about multi-entry. Second, to deal with the legislation that I've just handed up. And finally, come back to the immigration rules and at the same time make my submissions on both grounds of appeal.
Okay.
So turning first to my Lord Justice Lewis's question, why does it say multi? Very good question. The answer is that what under the order, as the court have seen, it converts into leave to enter once only, but once it's converted, the person can then come in and out during the currency of that leave to enter, and so the multi is there.
So what does once only mean in that case?
Once only means it converts once, so that's what the order says. It converts once into leave to enter, and once it's converted by operation of law, the person then has leave to enter and can come and go as they please until the expiry date shown on that vignette which we've given the court.
Okay.
So that the multi is customer friendly, as it were. When a customer looks at their passport, they don't care really about how it works. They know that they've got entry clearance and they can see an expiry date and they see multi. Multi means they can come in and out multiple times.
No, it all makes perfectly good sense. It's just let's not spend time on it unless it turns out to be contentious, but it's not what you'd understand from the language of the order, but there we are.
No, it's not. That's the way it works. So then the second part of my submission is to deal with the legislation I've handed up. So could I start? This pagination and tabs run on from the previous authorities bundle in the hope that it might make this bundle in this case. So starting first with tab 29,
yes,
I wanted to show the court first of all section 3A of the 1971 Act, which is the power for the making of the 2000 order, which I've already shown the court.
yes.
So sidelined section 3A3, the Secretary of State may by order provide that in such circumstances as may be prescribed, an entry visa or such other form of entry clearance as may be prescribed is to have effect as leave to enter the UK. So primary providing there that once regulations are made, they will provide that the entry clearance has effect as leave to enter.
So that picks up on my point about the distinction between a visa and a family permit, effectively.
Yes, if it's not an entry visa, it's another form of entry clearance. And then for completeness, 4, an order under subsection 3 may in particular provide for a clearance to have effect as leave to enter on a prescribed number of occasions or on an unlimited number of occasions during that period, or subject to prescribed conditions. And the limit in effect on the leave to enter in this case when it was granted was a limit as to time, because it's only for 6 months. And we've seen in the order how that took effect.
Very well.
And then, for completeness, my Lord Justice Lewis quite right to point to section 33, page 765 of the same tab, so that the court has it defines entry clearance.
Eligibility, yeah.
Turning then to tab 30, again for completeness and to show how the scheme works, and again rightly raised by my Lord Justice Lewis yesterday. Page 769 is the immigration rules on entry clearance, and Rule 25A is sidelined, and that reflects the 2000 order and the legal consequences which the 2000 order has.
So you say that's substantially identical, it looks like it is.
Yes.
Yep,
So
okay.
this is the immigration rules themselves recognising what the 2000 order does, and we would say if one's to read all of the rules together, then when one is looking at the meaning of the phrase at issue in this appeal, one has to take into account that the rules themselves recognise that an entry clearance has effect as leave to enter the UK.
Well, you say one has to this is just dotting a line, crossing a T, isn't it? I mean, whether you looked at the rules or the order, they're saying exactly the same thing, as sometimes happens.
Yes, and I would say in response to your Lordship's question, which rather reinforces my case, that other than the purpose clause, which I'll deal with, the weight of everything is on the side of the Secretary of State's interpretation.
Yep. Okay.
So then turning to tab 31, now this, I'm going to ask your Lordship to bear with me for a moment before I get to the exciting part. This is the EU Withdrawal Agreement Act 2020, and this is to address a question from my Lord Justice Underhill about, well, does any primary legislation refer to these appendices? Yes, it does, including this Act and some amendments it makes. There is also various bits of second...
Sorry, forgive me, I'm just making a note. What is the point you're addressing? My question I asked yesterday.
Question, but it is then relevant to...
I'm sure. Just remind me what it was, though.
Yes. So, your Lordship asked, are there any legislative references to these immigration rules? Have they got any grounding in legislation? Are they referenced anywhere?
Yeah.
Yes, they are, and I'll explain why.
Yep.
In terms of primary legislation, this Act, which is the Act which gave effect to the Withdrawal Agreement, there are also various references in other primary legislation and, in addition, in lots of pieces of secondary legislation. Now, before I take the call to the relevant provisions, I just wanted to say a word about the genesis of this Act and how we get to where we get to. So the court may recall that I said that yesterday there was a draft withdrawal agreement in March 2018.
Yeah.
Now, before that point, everybody was thinking, will we have a deal, will we not?
Yeah.
It gets to March 18 and then a lot of work begins in government to draft primary and secondary legislation to give effect to the withdrawal agreement, which at that point is only in draft. So there's a lot of drafting going on. There is a bill which doesn't actually become to be enacted, which was the Withdrawal Agreement Bill. That was introduced by Theresa May's government. And then there is the Withdrawal Agreement agreed in October 2019, as I've said, at which point the bill that becomes this Act at tab 31 is introduced on the 21st of October 2019, so not long after the agreement is negotiated. Now, nobody obviously turned that around in a few days. This was drafting that had been on the stocks for a while. Now, the reason that I'm saying that is because I need to explain as we go along a couple of things about the chronology.
Right.
So, could I first ask the court to turn to section 17, which is at page 794 of this tab, and just to read, there are two definitions there. This is all part 3, which is called citizens' rights. Could I ask the court to read section 17.1 and section 17.2?
Yes, are you going to explain it to us?
Yes,
I don't
insofar
quite
as I
understand
can.
the exception at the moment in 17.1a, but I expect I'll get there.
So, the first thing to say is this recognises two different schemes. It recognises resident scheme immigration rules, which is section 17.1a, Appendix EU to the immigration rules. So that's unusual to actually see a legislative reference to the name of a particular set of immigration rules.
Yes.
But then there's a catch-all, which is any other immigration rules which are identified in the immigration rules as having effect in connection with the withdrawal of the UK from the EU. What I'm going to do in a moment is take the court to the provisions where these definitions are used and explain why it was necessary to have them. The second is a definition of relevant entry clearance immigration rules, and the court will note here that the language is the same as the language in FP2. So in this part, relevant entry clearance immigration rules means any immigration rules which are identified in the immigration rules as having effect in connection with the granting of entry clearance for the purposes of acquiring leave to enter or remain in the UK by virtue of resident scheme immigration rules. So what this is basically a legislative device so that when all this legislation is being made which needs to refer to these two sets of rules, there is a means of identifying those rules. That's what it's doing as a legislative device. Now, this Act came into force in January 2020.
Hang on, it's just a legislative device. What was your phrase?
I'm afraid
You're doing it out of your head, so you can't remember exactly.
Could we wind the tape back? It was basically a legislative device so that when either primary or secondary legislation needed to refer to these rules, there was a way of identifying them, because unlike the resident scheme immigration rules where they're given a name, there has to be some other means of identifying them when they are referred to.
Yes, I see that. I mean, by the time this was passed, Appendix EU FP, as I'm calling it, did exist.
It did.
So if it was intended only to refer to that, you would have thought it could have just said Appendix EU FP, which is just as it did in A.
Yes, although that's why I gave your lordships the context at the beginning, because there was a lot going on and there was legislation drafted and on the stocks with things then developing and things moving quite quickly, which meant that things weren't necessarily done in the same order as they appear to
Yes,
be
I
now.
see. But does it boil? Tell me if I'm anticipating too much. Does your submission boil down to this? That 1B is in fact, for all practical purposes, a reference to Appendix EU FP.
No.
Two, yes. What one?
Your submission is exactly the opposite.
Yes, sorry, I meant what is sorry.
Not 1B.
Sorry.
No, it's 1 2. It's 1
Two.
2.
That was a slip of the tongue by me. Is your reference that 17.2 is a reference to Appendix EU FP?
Yes, that.
Albeit that the device of actually naming it was not adopted, and you basically say that's simply a function of the confused circumstances or in which the Act was drafted. Is that?
Yes, I'm being told that Appendix EU FP is caught by that definition, but there are other entry clearance immigration rules that will be also caught
well, that's
by
helpful.
it. So I'm being told Swiss service providers and healthcare. So although Appendix EU FP is caught by it, it's broader than that.
Yes, I see. So
now I have to
Your submission presumably is that in order to know if they're relevant entry clearance immigration rules, the rules themselves must identify them as having effect in connection.
Exactly.
It's a labelling, not a defining scope.
It's exactly that. It's labelling.
and what I respectfully endorse what my lord said. Effectively, when we see Appendix FP2, it is putting its hand up and saying this is an appendix. This is a set of rules of the kind referred to in 17.2.
Yes, that's absolutely right.
Yeah.
Exactly. Now, and I should say that although the court has already seen in terms of the chronology that the rules were made in March 2019, before this legislation came into force, but this is not the first time that that language in 17.2 is used in legislation, because before the immigration rules are made at the end of March 2019, and I haven't troubled the court with this, but the same language is used in secondary legislation to do with the immigration health charge. So at that point it's out there, so the rules then, when they come in, use that language because they then match up, so that anyone that's looking at that order to do with immigration health charges can see, oh, okay, these are the rules that are being talked about. So that's section 7.
Sorry, we don't want to be shown it. It'd be useful just though to have the name of that
Yes,
order.
absolutely. It is the I'll give the year and the number, SI 2019 number 686, and
Yeah.
it's the Immigration European Economic Area Nationals. That's
Immigration brackets.
brackets, yes.
Yeah.
Close brackets after nationals, open brackets, EU exit, close brackets, order 2019. And the
Okay, that's
provision
enough.
in that
Yeah.
is, it's an order, so it would be an Article 10.
Thank you.
Now, there's one last point to deal with on section 17, which is why does it say, for the purpose of acquiring leave to enter or remain? Those instructing me say that they are not aware of any present situation where entry clearance would be granted for the purpose of acquiring leave to enter.
Hang on 1 second. No present situation, is that the phrase?
Yes,
you
no
used?
present situation where entry clearance would be granted for the purposes of acquiring leave to enter by virtue of Appendix EU. To that extent, the reference to leave to enter is an anomaly.
Where is the label, but it doesn't have context?
Yes.
Content, yes.
And that's really all I can say about that language. Now, I just wanted to show the court sections 9, 10 and 11.
But is that slightly, that's very carefully worded? It goes slightly further than that, doesn't it? It's no present situation in which. That slightly suggests, oh, well, there might be other circumstances that they don't pertain at present. But in fact, given the structure of the well-recognised distinction between entry clearance and leave to enter, it's an anomaly always, isn't it? What would entry clearance for the purposes of acquiring leave to enter mean? It's basically saying leave to enter for the purposes of acquiring leave to enter.
Yes, the only thing I could think of was if, for some reason, and I don't know if this would or could happen, this was just my brain trying to come up with something. If the Secretary of State sat down and thought, oh, I think I'll design a special Appendix EU that applies at the border, and that isn't that, and I'm being told by the experts that, quite as your lordship says, it's very difficult to imagine a situation where that would be engaged.
Yeah.
Again, which is why I asked the court to have in mind the context of how this came to be drafted. It's not immigration legislation. It isn't perhaps drafted in the same way and by the same processes that immigration legislation.
But what you're basically saying, that you're being understandably coy about saying, is this is a drafting error. But it's not a draft, if you look at the overall context, it's not a drafting error which attracts the consequences that it's a drafting error only in the sense that it says something redundant and which actually, if you analyse it carefully, doesn't make sense.
Yes.
It's not so much an error, is it? It's simply that the label that Parliament choose to use for those things that are called entry clearance rules has words in it, which if you expect them to have any substantive content, you'd be disappointed if they don't.
Well,
They could
I call that a drafting error. It's a choosing a label, which if you analyse the label,
Yes.
isn't apt
Yes.
in one respect.
Yes.
They could have called it the marmalade sandwich.
Yes.
Oh,
yes.
sorry.
Yes, they could have done it, and this is why I wanted to show the court the provisions which do refer to entry clearance, because they rather show that if you look, if the court looks at the other provisions, that everybody knew quite well how it worked.
Yes.
So,
Well,
could I ask you? I'm so sorry.
Even amateur immigration lawyers, like the members of this court, I speak for myself. No, it's the relationship between entry clearance and leave to enter is one thing you learn very early on. Yeah.
So whether somebody had in mind, well, you never know, let's put something in, or whether it was a slip of the pen, or I don't know, I'm afraid. But that's all I can say about it. We have certainly on our side discussed that extensively. But I do want to show the court sections 9, 10 and 11, because they show that Parliament does actually understand how things work when making a substantive provision which refers to those definitions. So the first one is a regulation making power in section 9. Now this is on page 777. It's a regulation making power for the purpose of implementing Article 20. We need only look at 9(1)(a), Article 20 of the Withdrawal Agreement, and that fundamentally is all about bad behaviour. So this is giving the Minister power to make provision for the purpose of implementing Article 20. Now, before I look at 9.2, I'm now going to explain to the court why, before we look at it, why the legislation does what it does. The UK scheme is more generous than the withdrawal agreement, as I explained. So there will be people who can say, hello, I fall within the withdrawal agreement, I can rely on direct effect. There will be other people who can't, but a policy decision was made that those people should still benefit from the same rights. So that's why we then see the formulation in section 9.2, which is that if the Minister considers it appropriate, regulations under subsection 1 may be made so as to apply both to persons to whom the provision in question applies. So there being, hello, I can rely on the withdrawal agreement cohort. And then underneath that is persons to whom that provision does not apply, but, and then could I ask the court to read 1, 2 and 3? So that this will catch people who are out of country because all they've got is entry clearance but they haven't come in yet, C2B1. People who have leave to enter or remain, B, by virtue of resident scheme immigration rules, and 3, otherwise have leave to enter granted after arriving with entry clearance, granted by virtue of relevant entry clearance immigration rules. And that is the phrase that my Lord Justice Lewis picked up in FP11, which is recognising that anyone who has entry clearance, in effect, has leave to enter granted by operation of law. Note that that provision doesn't say anything at all about them having leave to enter under Appendix EU, because that's Class 2.
Yes, I mean, in fact, this is an oversimplification for reasons you pointed out to me earlier, but broadly speaking, 1 is out of country, 2 is in country with leave granted under Appendix EU, and 3 is in country with leave granted after arriving with entry clearance granted by Appendix FP.
Yes, and as I'll show the court,
and 3 would be an unusual group because that group would normally get their leave under EU. Appendix EU would fall under 2, but not always.
It's this respondent. It's this respondent who had entry clearance which converted into leave to enter at the border, but her leave to enter is...
Sorry, isn't she under 3?
She's 3, yes. She's 3.
3 couldn't be people who've got it under EU because it's relevant entry clearance integration rules, which are the ones defined in 17.2, I think.
Yes, that's right. Yes.
See somebody else nodding.
Yes, and what I'll say, and I'll show the court, that there is a qualitative difference between the Lim 2 leave to enter, which is granted by virtue of residence scheme immigration rules, and the automatic conversion leave to enter, because as I'll show the court, under Appendix EU, if you get limited leave, you always get it for 5 years. All that this respondent had was the 6 months that she got by operation of law, which was different.
All we need to remember is that there are two things in this world. There are residence scheme immigration rules, and there are entry clearance immigration rules. And the question is she getting it one or other?
Yes.
And that's all we know and all we need to know.
Yes, exactly. So that's how it works. So section 11, I won't go to it, it's on page 783, is a similar effect. That again is a regulation making power which needs to affect people who are out of the country because it covers appeal rights. But I will show the court section 10. What section 10 does is amend, and I'm sure the court will have come across them. Section 10 amends the deportation provisions, which are both in the 1971 Act and the 2007 Act, and it does that to exempt particular people from those provisions. So the formulation it uses, it's page 779. The First Amendment is to Section 3 of the Immigration Act 1971. It makes certain provisions, the court can see it too. What it's doing is prohibiting the Secretary of State from deeming somebody's deportation to be conducive to the public good if they are a relevant person. And this is to protect both people who are the, hello, I'm already within the withdrawal agreement cohort, and the people who are only protected domestically. So I just wanted to show the language that the court uses, the language that the legislature uses on page 780. This gets inserted into the 1971 Act, and it's this. So this doesn't need to catch people who are out of country because they're criminals. But it catches, first of all, someone who has arrived with entry clearance granted by virtue of relevant entry clearance immigration rules. That's our respondent, if she committed any crimes when she was here, which happily she didn't. And B, separate cohort, if the person has leave to enter or remain in the UK granted by virtue of residence scheme immigration rules. So apart from the oddity with section 72 or the marmalade sandwich, Parliament is well aware that this is how it works. And as we've seen, that's also baked into the immigration rules. Now, the court did ask yesterday why they're two different schemes. I just, if I may, I won't spend long here, but just because it's an important part of the context, could I ask the court to turn up tab 1, which is the withdrawal agreement? So starting first on page 8 of tab 1, Article 9, page 8, I'm sorry it's such awful small writing. Family members, just for the court to note, that's where it builds in the definition under Article 2.2 of the directive. And then Article 10 is the scope provision, which Honourable Justice Lewis is familiar with from the Chellick case. This says to whom the withdrawal agreement applies in Article 10, and the provision which applies to family members is E. There are two limbs to E. This is where we get the
Sorry, we're on 10.1e.
10.1e.
Yep.
This title should apply to, first of all, family members of the persons in A to D, which is essentially UK and EU citizens, provided they are either someone who, 1, resided in the host state in accordance with union law before the end of the transition period and continue to reside there thereafter, or, and this is what the term of art, the joining family members, or they were directly related to a person referred to in points A to B and resided outside the host state before the end of the transition period, provided that, and this is the dependency condition, provided that they fulfil the conditions set out in point 2 of Article 2 at the time they seek residence in this part in order to join the person referred to in points A to D. So that's why, and confusingly perhaps, when I talk about joining family members, it's this cohort who come after the end of the transition period. But obviously in normal language, family members could join before the end of the transition period. Now this
in fact, I'm not picking you up. Well, I suppose I am picking you up. The phrase "joining family members" isn't actually a phrase.
It's the word join.
It's the word join.
Join, yes, exactly. It's the join.
The key thing is that it defines them by meeting the conditions in Article 2 too.
It
And
does.
we must remind ourselves always that that is the one that requires them to be dependent.
Exactly. Now, exactly that. And then in terms of why they're two different schemes, because essentially, if the court turns to Article 14.3 on page 11, Article 14.3 permits the host state to require family members who join the UN.
So where have we gone to?
Sorry, page 11, Article 14.3.
Yeah.
This permits the host state to require family members who join the EU citizen after the end of the transition period to have an entry visa. And then it provides some conditions. So the entry visa scheme, which is Appendix EU FP, is different from the Article 18 residence scheme, which again, my Lord Justice Lewis will be familiar with from Chellick, and was also at issue in the Sadiqa case. So the withdrawal agreement effectively envisages the Article 18 residence scheme, which is optional for member states, and separately that member states can have an entry visa scheme. So the UK scheme broadly are divided up into entry clearance and then Appendix EU. But as I've explained, in some circumstances, by virtue of more generous rules, a person can have leave to enter under Appendix EU. So that's why there are two schemes, because it essentially fits with the withdrawal agreement. So I feel the anticipation building. We can now turn to the immigration rules. Could I turn to, first of all, just a quick point on Appendix EU family permit, because this is now going to make more sense, having looked at those primary provisions. So at tab 8, my Lord Justice Lewis referred to the provisions of FP 11, and that uses similar language of it's about revocation of an entry clearance granted under this appendix. And
I'm so sorry, I'm always behind. Which
I'm going
page?
too fast. 147.
Yep,
tab 8.
I have it. Yeah.
So that we looked at that provision yesterday.
Yep.
It refers to leave to enter granted by virtue of having arrived in the UK with an entry clearance that was granted under this appendix. So dovetails with everything that I've said. So that the court has them, the same language is picked up in the actual annex 3 times, which gives effect to, FP11 gives effect to these provisions. So page 180, there are 3 uses of the same language at the beginning of A3.3, A3.4 and A3.5. So 4 references to leave to enter granted by virtue of having arrived in the UK with an entry clearance that was granted under this appendix. No references whatsoever to that leave to enter somehow magically being granted under Appendix EU. Tab 9, Appendix EU, which of course the rules for the EU settlement scheme. EU1, this appendix, so not another appendix, this appendix sets out the basis on which an EEA citizen and their family members will, and then importantly the words, if they apply under it, be granted indefinite leave to enter or remain or limited leave to enter or remain. So the purpose of Appendix EU1 is saying up front, but if you want leave under this appendix, you have to apply for it. You don't just get it by operation of law. EU3A under requirements and procedure, next page. The first point I've mentioned to the court, EU3A, the applicant will be granted 5 years limited leave to enter if the application is made outside the UK, or 5 years limited leave to remain where it's made within the UK. So there's no provision for anything less than 5 years. If the upper tribunal were right and somehow this leave were magically granted under Appendix EU, it's completely inconsistent with EU3A because it's only for 6 months. The other thing to note there is that there has to be a valid application. The second bullet is the applicant has to meet the eligibility requirements for limited leave to enter or remain in accordance with EU 14A, and the application is not to be refused on grounds of suitability. Now, again, I'm going to show the court that provision in a moment because it's relevant. EU 9, and I won't spend time on this, sets out the requirement for a valid application. This is dealt with in our skeleton. There are 2 definitions there that are relevant: required application process and required proof of identity and nationality. The short point that we made in our skeleton is the upper tribunal's decision basically either allows these provisions not to apply at all, or essentially overrides them by saying you've made a valid application by turning up at the border and having your leave converted into leave to enter. EU 10 makes clear, just by the bottom hole punch, an application made under this appendix will be rejected as invalid where it doesn't meet the requirements in EU 9. So this system is not envisaging some other sideways way of getting leave to enter, either at all or for a lesser period. And one would have thought if under the immigration rules it were possible to have leave for a period of less than the 5 years, which are always granted, there would need to be some provision in the rules to sort that out. To say, but if you've got less leave because you get leave under this appendix by virtue of having entered with entry clearance, these are the consequences. It doesn't do that because it's blinkered. You're either in Appendix EU FP and then you get your leave to enter, or you're in Appendix EU, in which case you get 5 years. So that's that.
Sorry, it's my fault. Can I just go back?
Of course, of course.
Your argument that the decision of the upper tribunal effectively interferes with EU 9 as to what has to be proved in an application.
Yes.
And the 2 elements you identified were proof of identity and nationality, and proof of entitlement.
It's required.
Sorry, required application process.
Yes.
It's A and B. Now, the question at issue in this appeal is whether, when we get to C, under this appendix, can be interpreted to mean under Appendix EUFP, or only means under Appendix EU. But in either event, you're still going to have to comply with EU 9, aren't you? I don't quite understand why you say the UT decision dispenses with those requirements.
Well, because it says it proceeds on the basis that she has leave to enter, or she has leave to enter under Appendix EU, and yet she's got that, A, without making an application under it, contrary to FP1, and without making an application at all, in fact, and B, without making a valid application for it in accordance with EU 9. Because
sorry to interrupt you. The application we're concerned with is an application for leave to remain.
Yes.
Under EU, Appendix EU.
Yes.
And she filled in an application form.
Yes.
In relation to that, and it complied with the provisions of EU 9.
Yes, that's right. But the rule is looking back. The rule is looking back to say that she already had, because the rule is what the decision maker is applying when they make the decision, and they're looking back to see, do I need to apply a dependency requirement or not? And to do that, they look back at what have you already got, and if she's already got something, because of what happened back in December, that was before she made any kind of application under this appendix.
Well, there's no dispute about that. She has leave to enter as a result of having had the entry clearance and arriving. She had leave to enter. That's no dispute about that.
This isn't really a distinct point, is it, from your main point?
Yes, it's simply another point that we're making, that if the upper tribunal's right, a person can be treated as having had already leave to enter under Appendix EU, despite not having made an application for it and only having got it by virtue of operation of law. That's all the point is.
If C means what you say it means. I mean,
If C means what I mean, it's simply a...
Yes,
Yes, exactly. Can I just... Before we look at EU 14A, could I just invite the court to look at page 192, which is EU 16. This is about suitability. And again, this is important because of the phrasing used. Page 192, C1, which is just below the bottom hole punch. It again uses this language. So this is... If the Secretary of State...
So where are we?
EU 16. So the
Yeah.
Secretary of State is considering the application that's been made in country under this appendix. The Secretary of State has to decide, do I need to refuse this application on suitability grounds? What the rules look at is whether the applicant, and this is C1CC, had indefinite leave to enter or remain, or limited leave to enter or remain granted under this appendix, or limited leave to enter granted by virtue of having arrived in the UK with an entry clearance that was granted under Appendix EU, which was cancelled. So had this respondent been in the frame for a suitability decision, it wouldn't be because she had indefinite leave or indefinite leave to enter or limited leave granted under this appendix, which was cancelled. It would be because she fell into the second bit, which is limited leave to enter granted by virtue of having arrived in the
But
UK.
your point is simply here is an explicit reference in this particular context, an
Yes.
explicit reference to the fact that these are two separate
Yes.
kinds of leave to enter
Exactly.
under different appendices, which it goes further than simply the repeated use of the phrase under this appendix.
Yes.
It's more explicit.
Yes, exactly.
Yeah, well,
which
I see the point,
goes
obviously.
to, it goes to the weight of, yes, I accept the language of FP2 is odd, but the weight of the points on the other
Yeah.
side are all of these references and so on. And then looking just at the definitions and the meat of the point, the key definition, it stems from EU 14A, which is on page 191. So the condition which is engaged here in EU 14A is A, the applicant is a joining family member of a relevant sponsor. That is a defined term on page 216. So two things here. First, there's a reference to required evidence of family relationship. That's a defined term. And then the limb that's engaged here is E at the top of page 218. And that is dependent parent of the spouse or civil partner of a relevant sponsor. That then takes us to the key definition.
So hold on, so 2 and 8, I'm not with you on 2 and 8.
So it starts by looking at whether somebody's a joining family member of a relevant sponsor. So the gateway here is E. The child.
E.
Oh, I'm so sorry. Page 218.
Yeah, 2 and 8 E. The child auxiliary 3 is all dependent.
Dependent parent. So that takes us to the definition of dependent parent.
Oh, yes, okay, I'm with you now. That's the relevant. I missed out E.
And that takes us then to page 201.
Yeah.
And then the key limb. So we have dependent parent, the direct relative in the ascending line of a relevant EEA citizen or of their spouse or civil partner. B, unless subparagraph C immediately below applies, which is of course the Crunts provision here, they have to be dependent on the relevant EEA citizen or on their spouse, either at the date of application or at the specified date. And 3, so that's for people in country. 3, and that's the, I'm sorry, it's my fault. 3, the provision here, dependent on the relevant sponsor or on their spouse or civil partner at the date of application, and unless the relevant sponsor is under the age of 18, that dependency is assumed where the date of application is before 1st of July 2021. Here the application was in. And then C is the crucial provision. This subparagraph applies, and the applicant therefore has to meet no requirement as to dependency. It's not assumed dependency, as you just don't have to meet it at all. And I realise my Lord Justice Underhill says, well, that's theoretical, but it's different language here. Either the applicant was previously granted limited leave to enter or remain under this appendix, and that leave has not lapsed or been cancelled, curtailed or invalidated, or, and then a different provision. So
Well, yes. It is an oddity, isn't it, or am I missing something? That B little Roman 3 uses the language of assumption before the first, and C says that the requirement doesn't have to be met.
yes, it may be in part because, as we've explained in our skeleton, we say that C is an OTO, and I accept entirely that the upper tribunal was simply not helped by the Secretary of State on this point, which was completely regrettable. But the provision isn't OTOs because a person could already have limited leave to remain and make a further application for ILR, and in those circumstances they wouldn't have to meet any requirement as to dependency because they've already got through the gateway the first time.
But wouldn't why wouldn't you use the language of assumption in that second situation as well?
Well, because they're released from the requirement altogether, substantively, in the same way that people were released from the obligation to be exercising treaty activity at the end of the transition period. That the easement was really a caseworking easement, as I've explained, because there were going to be a lot of applications. It wasn't really, although it did benefit applicants, the point of it was there's going to be a lot of applications, let's just assume people are dependent.
Can I just have clear in my mind an example of when C will apply? And this is your paragraph 22, isn't it? This is the person who's had it under the old EEA regulations. They've returned to live outside the United Kingdom. They want to come back to the United Kingdom, and before they do so, they say, I want entry clearance and I want leave to enter.
Yes, so there were 2 different OTOs points, I think, if you like. So the first point is, when would somebody be able to apply for leave to enter in the first place under Appendix EU, and that's the specified relevant document point.
Yes.
So that will be somebody who's, the classic case is they've had their document and then they leave and they think, right, I want to come back, so I'm going to just apply off the bat for limited leave to enter. I'll get my 5 years and I won't have to worry about it again until it's time to get ILR.
And they want to do that, and they want to get the 5 years before they pack up their belongings in Amsterdam. They want to be sure before they get on the boat to Harwich or the train now that they've got it. And that's one example.
That's exactly that. Yeah. I think it's not so much an example of C, but it might explain why somebody would previously. There are 2 things that C does. One, it refers to somebody who's got limited leave to enter, and it explains how somebody would have got limited leave to enter. And the other thing it does is say, when you make your second application effectively, you don't need to show dependency.
Exactly. You've done it once when you came under the EEA before you returned to Amsterdam.
Exactly.
And you're coming back, and they're just assuming, or not requiring you to prove the second time that which you would have proved the first time under the
So, but hang on, that under the EEA, would you have shown had to show dependency?
Yes.
Yes.
But they may be somebody who's it may also bite on somebody who hasn't done any of those things and just been here all along and got themselves limited leave to remain under
Yes.
the EU settlement scheme.
That's right.
They wouldn't have needed to show dependency once the scheme came into place, and then when they apply under this provision for their ILR, they don't need to show dependency the second time either, because they didn't need to show it. I'll turn my back. I'm so sorry. Yes, so I'm being told you do. Sorry, you do. My Lord Justice Lewis's point is absolutely right. My point was wrong in the sense that you may have limited leave to remain under Appendix EU, but I'm being told that you would need to show dependency on your first leave to enter
Yes,
application.
So this second class is simply a bad point.
No, there is a second class. There is a second class who will already have leave to remain under this appendix. And then they apply for settled status. What the point I would need to check is whether they would also need to have shown dependency to get their leave to remain.
Depending on when they apply.
Yes, depending on the date of application. Yes.
The person who came from Holland to live with their son moved back to Amsterdam to live with their daughter, and she's dependent throughout. Daughter sadly dies. She moves back to England to live with the son. She's proved the dependency on the son first time round. She can come in under this without being required to prove dependency. True it is, whilst she's been out of the country, something's happened. She's either won the Dutch lottery or some other person has looked after her. But you don't, as the Home Office, because you're so kind, force them to go through that again.
No.
It's just carrying over a pre-existing status.
I'm so sorry, my lord.
She doesn't, when she's got her regs BRC at that stage, she doesn't have leave to enter.
She gets leave to enter.
Not automatically, she needs to make the
Yeah. So for that person, it depends on the date of their application as to whether dependency is assumed. It's the same, whether it's made before or after the 1st of July.
It would have been very helpful, I have to say this, with the second day into the hearing of a case has been, to have these examples, which are very important to your case, fully worked out and put in your skeleton.
Yes,
We're still trying to explore what they are and how they work.
I see that, my lord. I
I'm
can
sorry,
only apologise.
it's just a letting off steam, but
Yes, no, and
we
I
do
understand.
need to understand these things, and you
Yes.
come up points, and then is that
Yes,
right? And
we certainly explored the examples that I've given. The problem is there were lots of different scenarios, but I
no, I
entirely
know,
accept
but that's
your
all the more
lordship's
important
point.
to get them down with all
Yes.
their bells and whistles.
Yes.
The I was having with your last answer is that whatever the scope of C, it's not by reference to any point of time.
No.
If C applies, it doesn't matter
But it
when
will,
the application is.
the classic situation when C will apply is somebody's already got their limited leave to enter or remain and they're applying for ILR. That's when C will apply.
I understand that may be the main scope of it, I understand.
Yes.
But it does say leave to enter as well, you see, that's the problem. You know, that doesn't have any practical thing. And I'm trying to work out when C will apply, because it's got to have some meaning, and a meaning that ties it to the residence scheme, and the fact that you've come under the old 2016 regulations makes sense to me. But if it isn't that, and if it's something else, then I do begin to wonder what the words leave to enter mean. But you will say it doesn't matter because whatever they mean, and they're opaque, it's still what this applicant has got, you say, is not got it under this appendix.
Yes.
Well, I suppose it could apply to someone who's doing the whole thing out of country. There's a small class of people who can apply for leave to enter out of country under Appendix EU.
Yes.
They may not yet have come.
Yes.
They've got 5 years within which to exercise their right to come, and they may think, before I come, I'll make an application for leave to remain.
Yes, I think the narrow point really on C is that what it's referring to that is somebody who was previously granted limited leave to enter or remain under this appendix as a dependent parent. The first question is who that catches, and the second question is why. In relation to the first question, who it catches, the point is that there will be people who have either previously been granted limited leave to enter under Appendix EU, so that's not an empty class. However they've got that leave, and I accept that I can't at the moment give chapter and verse on certain of the circumstances, but as in terms of this case, the fact is there will be people who exist who have been given limited leave to enter under this appendix by making an application under it in accordance with the validity requirements and complying with all the other bits and pieces.
And the proof of the pudding on that is that there are some circumstances which we've looked at
Yes, exactly.
in which you can make an out-of-country application
Yes.
under Appendix EU.
So that's the first question.
I'm sorry if I'm being slow. but
No,
that's-
not at all. I
that's
think
how
it's
I'm
me.
looking at it.
That's as I see it. There are two questions: who does it catch, and why does it catch them? And in relation to the who does it catch, that is absolutely not an empty class. The class that has limited leave to enter under this appendix. What the one point is, in various situations, would they or would they have not needed to show dependency to get their limited leave to enter? But in my submission, that doesn't affect the primary point, which is they have already got something under this appendix. It will either be limited leave to enter because they got it out of country, or it will be limited leave to remain because they were already here and they applied for it. They may or may not, and that is the question, depending on various different circumstances, have had to show dependency. But the point is, on their second application, they've already got through the hurdle once. They've got through Appendix EU because, as the court will see, this is a lot longer than Appendix EU FP. They've got their leave under this appendix first, and then they need to get their indefinite leave to remain. They don't need to show dependency. So that class, and as I said, my instructions were in the first leave to enter application, depending on the date, there may have been a need to show dependency. So that for those people, they will already have shown dependency. So that's in my submission the why rather than the who does it catch. And in my submission, very clearly on that language, have you got limited leave to enter or remain under this appendix? Well, what is it? It's where you've made an application for it. What will it look like? It will be 5 years leave. Is it entry clearance? No, because that's something else, as we've seen in all the different bits, and that really is the heart of my case on the interpretation. Not the end of my submissions, but close to them.
And this,
Right, I'm being directed back to paragraph 22 of my own skeleton argument.
Yes, that's the example, I think.
It's not, which is obviously drafted on instructions.
Yes, you've got the 2016 regulation permit with the biometrics.
I'm so sorry, Mother. Yes. So yes. So to answer your lordship's question, if they were in the class of people who were the specified relevant document and they were resident in the UK before the end of the transition period, then they wouldn't have needed to show dependency because that's never been a requirement. The cut-off date for them for making the application is the 30th of June 2021, which is how the two dates dovetail, apart from the fact that they can make a late application. So for anyone who was in the country before the end of the transition period, they have never needed to show dependency. But by definition, because the requirement was to have been here before the end of the transition period, the Minister wasn't as concerned about time. The issue about proving dependency is really for joining family members.
Yeah.
And that's why there will be a number of different examples depending on the person's circumstances
Yes.
when they applied. And
Well,
what
perhaps
they
I was
applied for.
unfair in my observations just now.
Well,
Because it is there in paragraph. It's just very difficult to understand until one's been steeped in it.
I accept entirely, my lord, and that's the same for me, and I have done a lot of these cases. So that there are very, very many different factual circumstances. So the only other things I need to show the court in here is first, I mentioned page 241. I mentioned required evidence of family relationship. That appears on page 241. and the relevant bit there is on page 243 by the hole punch at D. All that does, but it's right that the court, I think, has all of the defined terms. What D effectively does is refer back to earlier provisions, which mean that you don't need to prove dependency if it's a case where it's assumed. And then the only other thing I wanted to show the court in this appendix is that when it means Appendix EU FP, it says so, which goes to interpreting things in context. So we gave 3 examples in our skeleton. I'll show the court the first one, which is on page 204. This is the definition of dependent relative, which is relevant to a different class of family member. So page 203, dependent relative. I'm not suggesting this is relevant to this case. What I'm doing is saying, look, when it means to refer to Appendix EU family permit, it does. So that is page 204 at the top. The court will see an express reference to Appendix EU family permit. We gave 2 other examples in our skeleton argument at paragraph 34. I won't take up time now, but for the court's note, page references in the authorities bundle are page 224 for the definition of relevant document, which is also to do with extended family members, and page 230, which is the definition of relevant EEA family permit case. Those are some examples of when it means Appendix EU family permit, it refers to it. When it means this appendix, it says this appendix. So that then just leaves me, I think, to draw the strands together. And effectively, we say this, that I'm going to start that there are scales. I'm going to start with all the things on the side of the Secretary of State's interpretation, which we say overwhelmingly point to the Secretary of State's construction being correct. So I'll make 5 points, which I'll do briefly because it's drawing together things I've already said. So the first is the language of the relevant provision that we're looking at. We say the clear meaning of this appendix is this appendix, Appendix EU. And the connected point is that both Appendix EU and Appendix EU FP frequently use the term this appendix. They use that when they're referring to.
So is this all part of your first point still?
Yes, it's all part of the language point. They use that term when they're referring to themselves, and when they want to refer to the other appendix, they use the name of it. So there's no reason whatsoever in my submission to treat the provision at issue in this appeal any differently. So that's the language point. The second point is the context and background. And the headline point there is, well, one has to construe these rules in accordance with the way the system works, which is that if you have entry clearance, you get leave to enter by operation of law. So, as I hope I've shown the court this morning, the whole scheme of immigration law proceeds on the basis, and I've shown the court primary legislation, secondary legislation, the immigration rules. In fact, no, I haven't shown primary and the immigration rules. Essentially, proceeds on the basis that you get entry clearance and then you get leave to enter by virtue of the fact that you had entry clearance by operation of law. So to construe C, the provision at issue in this appeal, as, well, no, for some reason in that situation, it's not leave to enter by operation of law, it's leave to enter granted under Appendix EU, is completely at odds with the system of immigration control as it works. And as I've shown the court, the rules themselves recognise that that's how it works in various places. The third point is that it's a context and background point, but a slightly different one, which is the intention, as we've explained in our response to the Air Centre, was to bring the position into line with the withdrawal agreement. and it is in line with the withdrawal agreement to have to show dependency. For the consequences point, the first is that under Appendix EU you get 5 years limited leave to enter. It's not possible to get anything else. So if you've got less, then you can't have got it under the appendix. It must have come from somewhere else. We know where that is. It comes from operation of law. The consequences point is that if somehow it comes by a side wind under Appendix EU, that's a mess. How does this applicant know how long her leave is, what anything? So one has to be clear, her leave is leave to enter granted by operation of law, because then she knows how long it is. It's a mess if somehow by a side wind.
If it's to be treated as if it were granted under EU, Appendix EU, then she would know, because if it were treated as Appendix EU, she'd have 5 years.
Which one?
You're looking at the end
yes,
result to determine what she's got.
But then that's, yes, but then that's a consequences point, which means somebody gets 5 years limited leave to remain, despite not having applied for it.
That's your other point.
That's
actually.
my other consequences point. Yes, I accept your lordship's point, but then my other consequences point kicks in.
Mm.
And I've already said that it's not OTOs. And then my final point is really just to respond to the rationale point that's been made against me and court rightly tested me on yesterday. And again, I'll refer to what we said. I don't have, as I say, evidence or so on, but what I can say is what we've said in response to the Air Centre, which was this was because a large number of applications were expected, and so the cut-off date was so that decision makers, if an application was made by the 1st of July, because that was the biggest crunch point, decision makers would not need to distinguish between resident family members, who, as I've explained, did not need to show dependency. When I say resident, I mean before the end of the transition period. This is in paragraph 11 of our response to the Air Centre. There wasn't, that was the crunch point, because people already here had until the 30th of June, but other people were also applying as joining family members. And so a decision was made, right, this is going to put a lot of pressure on caseworkers. Let's just say, for any applications made before the 1st of July 2021, we will assume dependency.
That explains only why it's, as it were, there's an extension of, you'd have the same problem, wouldn't you, if there hadn't been that extension and the rules had changed as at the 31st of December.
I don't think I've understood the question.
Well, I'm not quite sure what you're explaining.
All I'm explaining is why did the Secretary of State put this easement in place?
Why did they make an assumption? You're saying because they thought they'd be flooded and they just didn't have the time to check whether are you coming in so you need to show, or are you already here so you don't?
Exactly.
That's what you're saying.
That's all I'm saying. And
Yeah.
the point is that it wasn't then, it's about caseworking. So when the court says, well, isn't it unfair if you manage to get your Appendix EU family permit entry clearance before you needed to show dependency, but then you're caught by the second? That wasn't the rationale for it. So I accept that somebody might say that's unfair. We would say not, because somebody should have known from the outset that that was the position. But to the extent that it has an impact, that wasn't what it was intended to do, and that's why there's a cut-off. So
and it's really relevant because we are actually dealing with rules of law and we are doing construction.
yes,
And it's really a negative point. I mean, for
It's
myself,
dealing
I
with the
wouldn't
point-
want to interpret rules by reference to that.
yes,
If I thought the rules had absurd consequences a la Albania,
yes,
then I might think, well, did Parliament
Yes.
really mean that
Yes.
when they approved the rules?
yes.
But it's really a negative point.
It's
It's,
a
not a reason why you
It's
interpret.
a shield.
It's a reason why you don't depart from that.
Yes, it's my.
Or-
Yes, it's my. Your lordship's quite right. It's my shield point.
Yes.
But it was nice to have 5. There we are. So that's everything in a nutshell. And as I've gone along, I say is on the Secretary of State side, and on the other side of the scales, we have the purpose clause. That's it. And the first headline point, and Bennion would tell us this, is that a purpose clause can't undermine the scope of clear provisions to the contrary. The second point is if one looks at FP2, it's very general. It uses these words in connection with the granting of entry clearance for the purposes of acquiring leave to enter or remain. we know why it's there now. It's there to say, hello, we're the rules for those purposes. But the point is that whatever that clause says, there are various other provisions that say something very different. And crucially in this case, even if it were somehow, the fact is that this respondent did not have leave to enter by virtue of Appendix EU. As a matter of law, she had leave to enter by virtue of the 2000 order. So whatever that purpose clause says, it can't, we say, A, undermine the legal position, and one must, in my submission, start with the legal position, which is, well, what is her leave as a matter of law? And B, nor can it undermine all of those other weighty interpretive factors like language and context and so on. So that those are our submissions in a nutshell. I've taken up a lot of time, for which I apologise, and perhaps, yes, we'd originally thought this case might take a little longer and then thought perhaps overconfidently that it wouldn't. Those are my submissions. I can take the court to the upper tribunal decision, but I see the time. I've accepted that the upper tribunal asked the question and was given the wrong answer, regrettable, and I've also accepted that it was not helped at all on the 2000 order. But I think it will be clear from what I've already said why we say the upper tribunal's decision is wrong. So unless the court needs anything else from me,
Can I just check? Assuming you're right, if you're wrong, it's easy. We just must. If you're assuming you're right, there's still the point as to whether or not there was procedural unfairness because she wasn't asked, "Are you dishonest?" which is what the tribunal found. So what are you suggesting? That it goes back to the upper tribunal, they decide if there was procedural unfairness, and if so, they remake it, or does it go back to the FTT?
Well, we don't take a point on that. So there are 2 points really. One was what Lady Justice Elizabeth Lang floated when she granted permission, which is that this court gives a decision on the law but doesn't set aside the upper tribunal's decision as a possibility. Certainly, I mean, the Secretary of State's priority is that the law is clarified if we're right. The second point, if we're right and the court wants to set aside the upper tribunal's decision, we certainly agreed with the respondent that there should be a remittal, and if the appellant wanted to call, if she wanted to call evidence of dependency, of course.
Well,
So
there doesn't seem to have been a decision, an actual binding decision, that there was procedural unfairness. That's the first question. And if there was, then the decision would have to be remade. So is it the upper tribunal to decide that? Or are you saying you're conceding there was unfairness and therefore it would have to go back perhaps to the FTT?
Well, I certainly don't have instructions to, we haven't appealed on that point, that there wasn't unfairness. I think we would say it should.
There wasn't a finding to appeal against, was there?
That's true, yes. But I think we
And this is simply a question of what we should do in these circumstances. And you're saying you don't take a position. Well, you're entitled to say that, but
send it back to the upper tribunal to remake the decision in full.
Well,
yes.
send it back
Including
to
with
decide
facts.
if there's procedural unfairness, and if so,
Yes.
remake.
I
That's the point.
I don't think those instructing me would say that the findings of the first tier on procedural unfairness should. The findings of the first tier on the facts should stand. I think it would certainly be we would submit to go back for the decision to be remade in full, albeit with the upper tribunal effectively sitting as the first tier.
All right, but I mean, I don't want you to take a point you don't want to take, but I haven't focused on this. Perhaps it'd make more sense just to hear Mr. Metzer on it, but my reading at the moment is they simply didn't address the question of procedural unfairness, or whether that, in fact, but for the procedural unfairness, there was dependency.
They didn't, no.
Because none of that needed to be decided, because they said dependency didn't need to be shown.
They said,
and therefore, if it goes back, everything should go back to the upper tribunal in the first instance. They've got power to do whatever they want.
yes, although then if the upper tribunal decide, so the upper tribunal could decide again that there was procedural unfairness
and remake the decision, hearing further evidence as the first tier tribunal should have heard.
To be strict about it, they're not deciding again, because what they say in paragraph 3, we harbour grave doubts about whether it was open to the judge to reach findings about dishonesty.
Yeah.
However, we do not need to reach a considered view. And they didn't preserve the findings because they thought findings of dependency were not necessary. rather than that the findings were procedurally unfair.
Yes, and I think out of fairness to the respondent, what I can say is that the Secretary of State did not, so far as I'm aware, raise any issue in the upper tribunal defending that part of the first tier's decision, but I accept that the upper tribunal didn't decide it. Can I perhaps...
Sure. I'm uneasy about doing anything other than sending it back to the upper tribunal.
Yes, understood.
Decide what the right thing to do is. They didn't make a decision.
Yes, so they remake it in light of, if I'm
No,
right...
They decide the second ground of appeal was procedurally unfair, and if so, they then
Yeah.
remake it.
It'd be open to you at that stage, in a considered way, to
Yes.
make a concession.
Yes.
It was unfair.
Yes, yes, I think...
But I'm not comfortable about you being asked to make that concession now. Unless you haven't come here with a considered position. I'm sure they'd be delighted if you do. And if you are in a position to make that concession, perhaps having taken instructions over the short adjournment, fine.
So,
But all you've said so far is you're not sure the point was really taken below. We just don't know. And
what I have said expressly is that we do not object to there being a remittal on the question of dependency, which would seem to be a concession.
well, that's not much of a concession. There's got to be. It is obvious that if the question of dependency is live, because you've won on the main point, it's got to go back to the upper tribunal to decide, just as my lord said, whether the FTT's finding that she was not dependent can stand. To which the first hurdle was it reached by a procedurally unfair route? All that really, I'm thinking aloud here, but I hope it's helpful to Mr. Metzer, has really got to be sorted out in the upper tribunal, unless you make an explicit concession, which I'm not discouraging you from making, but I don't think you should just say, oh, well, I'm not sure, or it doesn't seem to have been taken below. By all means, take instructions. I would encourage you to do so, but unless and until you make a concession, it's got to go back.
Yes, perhaps I should stop trying to think on my feet for a moment, and I should let Mr. Metzer deal with it, and I will take instructions, and Mr. Metzer and I may be able to agree something between us.
Yes, well, that would be helpful.
So,
thank you very much, Ms. Smythe. Sorry, we've given you a hard time, but you have coped with it well, and we're most grateful.
Your Lordship is very kind. It's all good fun. Can I just turn my back for a moment? Yes, thank you.
Yes, Mr. Metzer, you're getting to your feet rather later than you expected. You obviously have got as long as you need,
Thank you, my lord.
but we have covered a great deal of ground, so I'm sure you can be a lot shorter.
I will be a lot shorter.
Yes.
Can I take very shortly, we've called it grounds 2 and 3. I think that's probably an overstatement within the position. As far as what we called ground 2 of opposition is concerned, that really turns on what Her Ladyship, Lady Justice Lang said in relation to paragraph 14 about the inherent unfairness of the position, even if the appellant would succeed on the primary ground. Bearing in mind the history, and I'm grateful to Malone for Ms. Smythe's indication that this is very much an appeal to clarify the law in relation to the position.
Yes, if you lose, it will have to go back.
Yes.
And unless there's any agreement, and there might be, but we're not in a position to say, it will go back on the question of whether the First Tier Tribunal was reached its conclusions by an unfair basis. And if it did, one suspects the upper tribunal will want to remake them itself rather than send it back.
My lord, that's great. That's
Okay, so we can leave that now.
We can leave it. Can I just make 2 very brief observations, and then we will.
Well, yes, go on. Yes.
First is this, that it is not insignificant what's said at paragraph 14, I think, of Lady Justice Lang's, when she granted permission to appeal in relation to the specific point about whether it was unfair more widely in relation to this particular respondent. Of course, she's our client. But more fundamentally, it would, I think, be of considerable assistance to the upper tribunal further down the line on the question of resolving, as my Lord Justice Lewis rightly observes, it's clear from paragraphs 22 and 23 that they simply didn't need to determine the question of dependency. It would certainly make it a much cleaner and clearer for the upper tribunal if they were to focus on that question in relation to unresolved question So I'm not going to take it further now, but
Well, no, but sorry, Martin, my lord. You say you're not taking it further now. I mean, conveniently, we're dealing with it now at the start of your submission, so I don't want to have to come back later. Are you? You referred us to what Lady Justice Elizabeth Lang said in paragraph 14. I'm not clear, but I don't think that you're actually inviting us or submitting to us that we ought to take up that suggestion. It was no more than a suggestion.
no, it's just an indication of a recognition of the contention that it is open to the appellant in careful consideration to consider her position in terms of.
Well, that's fine, but you're not asking us to say that simply because of the history of these proceedings, we will declare the law in some abstract sense, but not apply it in this case.
No, I think we have to recognise that if we lose on the main ground, the appeal has to be allowed. We do,
Good.
of course.
Well, that's helpful.
But it is perhaps of some assistance in terms of the considerations that are now being thought about. And in relation to what we call ground 3, it's really a remedies point, and we respectfully submit that the only possible and correct course, if the appeal is allowed, is to remit the matter back to the upper tribunal to determine the question of dependency, and then, in theory, it's still open at this stage to consider the question of procedural unfairness, but that may be resolved.
It's the other way around. At the moment, if we allow the appeal on the meaning of the appendix, what will be remitted is the undetermined ground 2 was it procedurally unfair. If they find it was procedurally unfair, then they will remake. If both of you agree that the Secretary of State is going to concede that there was procedural unfairness, then the issue for the upper tribunal will be different. They will say, in the light of the concession, the decision of the First Tier Tribunal can't stand. Should we ourselves remake it, or should we hand it back down below? That's the process.
My lord, I absolutely agree, and I'm simply saying that it will be helpful clearly further down the line if the issues could be narrowed further down the line.
Yes, well, I'm sure they could be, and I think we better not express a view whether in that scenario they ought to send it back to the TT or deal with it themselves. Enough said. They certainly have the option, which will in some ways be attractive. They deal with it themselves rather than start all over again. Yeah.
Well, thank you very much. That's all I need to say. So in those circumstances, I hope I can be relatively short in relation really to the main ground. My lords will understand that we respectfully submit that these two appendices should be read together, considering the purpose and the role of each of them, because we say the focus of paragraphs FP1 and FP2 of Appendix EU FP, and I'm not going to go back to them quite yet, although I will need to, but of course you'll know that's at the authorities bundle at page 509. And we do respectfully rely heavily upon what paragraph FP2 expressly states in relation to the purpose of Appendix EU FP, which we respectfully submit operates in tandem with Appendix EU. I can, of course, go back to it, but I know my lords will have it very fresh in your minds. And we respectfully submit that is the wording of paragraph FP2 is of considerable significance, because it says in terms, this appendix has effect in connection with the granting of entry clearance for the purposes of acquiring these words, leave to enter to all remain in the UK by virtue of Appendix EU to these rules. And my lords have heard what my learned friend in her very, if I may say, very eloquent submissions before the court in relation to the question that was asked yesterday about what do the words leave to enter mean in the context of FP2 of the rules. And we respectfully submit the response, both initially in writing, which didn't in the greatest respect specifically deal with the what FP2 adds or doesn't add in relation to the nexus we respectfully submit to the two appendices, but even when you've heard now from a learned friend in relation to FP2, it doesn't adequately explain or clarify the point or the purpose by which paragraph FP2 of Appendix EU FP is there in the immigration rules. and it is challenged, what is contained in Malone and Friends skeleton at paragraph 20, that these two appendices are wholly separate and have an independent purpose. And then clearly that's going to be, you've had a considerable amount to consider in relation to that question, but my lords can certainly see the battlegrounds in relation to that specific point. There is a reference in the EU settlement scheme travel permit that we would like to address, because we say it has some relevance. That's at FP6. So may I take my lords to that? And that's to be found at page 145.
Starts at 144.
It does, thank you, my lord. Yes, certainly does. And what we say about that is this is an application for those who hold relevant documents under the EEA regulations. And the reference to the EU settlement family permit is contained within in the authorities bundle. And if you look at,
Sorry, you lost me. FP6.
yes, and my lord,
Are
right?
you saying this is a point about the travel permit, which we see referred to in FP1B? Is that
Yes, we say it has some relevance, and I hope my lords will bear with me just a moment in relation
Right,
to that.
I've begun to lose me, but maybe you'll catch me. I'll catch up.
If it's not a good point, we can move on perhaps primarily to this.
Let's develop it, and then we can see whether it's a good point. Yeah,
You can see it FP6(3)
yeah.
at page 145. We say, and there's a reference there to the applicant meets the eligibility for an entry clearance to be granted on this appendix in the form of an EU settlement scheme travel permit. This reference is an entry clearance application for returning family members of EU nationals, which demonstrates, we respectfully submit, that
Sorry,
returning
what were you just saying again? This,
I'll say it more slowly, sorry.
yes, I wasn't returning EU nationals. What does that mean?
It's returning family members of EU nationals. This is an entry clearance application for them, which suggests and demonstrates, we say, that returning family members are a separate and different cohort from joining family members.
Well, where's this phrase "returning family members of EU nationals" come from? It's not. I don't see it in FP6. 3.
Yeah, we understood that that's what my learned friend referred to yesterday, so we...
She just said rather firmly that I've noted on the NU does this help, but FP1B, JS no. So I thought we didn't have any submissions about what it meant. Have I misunderstood?
It may be that we have, my lords. We understood there was a specific reference to returning family members.
Miss Smythe doesn't
No.
recognise that. But don't worry, Miss. But let's not worry about what she said. No, don't worry about what she said. What are you saying?
All right. Give me 1 moment. Maybe I'll just move on directly to the central point.
Up to you.
My lord, I'll come back to you if I need to. It might
Okay.
be
No problem. Thank you.
Can we, taking the point board, since we're at the page, we will deal with FP2 now. Our board submission is that FP2 is not a freestanding provision, and the discussion that has happened so far in relation to its purportedly or allegedly its anomalous status is something that is challenged on behalf of the respondent, that it doesn't have has validity and value in relation to its content. We would ask, can I ask my lords please to look at the document which was handed up loose leaf?
Yes.
The explanatory memorandum. it's if it helps, my lords, although quite a bulky document, I'm only going to take you to a very small part of it.
Very good.
Can I ask you please to look at page 17?
Just before we get there, you must tell us what it is. The explanatory memorandum for an alteration to the rules on the
Yes.
7th of March 2019.
2019.
So this is the introduction of Appendix EU and FM first time round.
I think it is what was the first time round. Yes.
Yes, okay, hang on 1 second. Sorry, which page did you want us to go to?
I'm going to go to page 17, please, my lord.
Yes.
The court will have very much in mind that the appellant's position is that Appendix EU family permit is wholly disconnected from Appendix EU,
Yes.
and that, taking it very shortly, and I hope fairly, an applicant who's applied and granted a family permit could then go on to apply for a different form of leave. For example, I think examples were given yesterday of student or temporary leave. Secondly, having already applied for and been granted under EUFP. We respect...
Yes, I mean, I think her position was that primarily it would be used, and it was anticipated that if you had got your entry clearance and thus your leave to enter under FP, you would probably then be making an application for longer leave to remain under Appendix EU. But Ms. Smiley did make the point you didn't have to do that. You could have applied for a different form.
Yes.
But we're in the same place. Yep,
Yes,
all right.
we are. Thank you very much, Mum. So can I ask you look at these at page 17 at 7.66?
Yes.
Because it states this. This statement of changes in immigration rules makes the following other provision associated with the EU settlement scheme. Consistent with the draft withdrawal agreement with the EU, the new Appendix EU family permit provides for a non-EU EA Swiss citizen who's the family member of an EA Swiss citizen with status granted under the EU settlement scheme to apply for an entry clearance to join the EA/Swiss citizen in the UK or to accompany them here. And then these words, whether for a short stay or to make an application under the scheme in the UK. So this seems to envisage the statement to change the application for further leave, whether for a short stay or an application under the scheme. And completing the point, really, if you look down a little bit, 8.1, under the European Union Withdrawal Act, withdrawal of the United Kingdom from the European Union. This statement of changes in immigration rules is not being made under the European Union Withdrawal Act, but it relates to the withdrawal of the United Kingdom from the European Union because it supports implementation of the EU settlement scheme. So, what we respectfully submit is if the appellant is right in relation to the submissions that you've heard from a learned friend, there's a difficulty, I mean, enhanced difficulty or further difficulty with the interpretation presented in relation to FP2. Because FP2, we know, and don't think I need to go back to it, it talks about this appendix has effect in connection with the granting of entry clearance for the purpose of, and these words, acquiring leave to enter or remain in the UK by virtue of Appendix EU to these rules. So it is our submission that when one looks at FP2, it breaks down into two possible scenarios. Either Appendix EU FP has the effect of granting entry clearance in order to obtain further leave later on under Appendix EU, and we've looked at the statement of changes in relation to that, which we respectfully submit is consistent with that interpretation, which establishes a direct nexus between the two appendices, or, as was argued in our submissions, which is of course what the upper tribunal found, that entry clearance was granted under Appendix EU FP, and this then becomes leave to enter under Appendix EU, or remain if an application is later made under Appendix EU. in relation to the application point, which you've been addressed about, of course, the respondent did make an application under Appendix EU as she complied with the relevant procedure.
That was after she got entry clearance and after she'd been in this country for 5 days. She then went back to Albania.
That's right.
And there were 2 separate physical events, an application for entry clearance and a subsequent application for leave to remain.
That's right. It's exactly the history. So we respectfully submit that when one looks at the possible reasoning behind, because we respectfully submit FP2 is central to a full understanding of what is being envisaged. That either way, FP2 helps in relation to showing a clear nexus between the 2 appendices, and that leave to enter becomes such by operation of FP2 and Appendix EU. Otherwise, we respectfully submit, and we ask it rhetorically, but it is important in our respectful submission, what is the purpose of FP2 at all? Although the submissions have been, I'm sure, of great assistance to the court, it doesn't really address, in our respectful submission, what FP2 was seeking to say or do. And we hope that the statement of changes there helps in relation to assisting as to what was really the significance and the importance behind FP2. Because it's envisaging a situation where there is a further application.
Or not. The first bullet point suggests that alternatively it might be there just to enable one to come for a short stay and not make an application.
Yes, of course, there is that scenario, absolutely. But it certainly envisages potentially a further application. Can I now move on? So that is our we hope the state of change assists, and we do respectfully submit that you simply cannot ignore FP2 and essentially just regard it as something which is an anomaly which doesn't seem to fit with everything else that you've heard submitted, and therefore essentially leave it aside. And we respectfully submit. Can I ask you please to look at page 92 of the authority manual? I'll come to the order. You've been taken to this, but Article 2, we can see in relation to entry clearances, leave to enter, says subject to Article 6.3, an entry clearance, and these words we're going to accentuate, which complies with the requirements of Article 3, shall have effect as leave to enter in the United Kingdom, and then these words to the extent specified in Article 4, but these words subject to the conditions referred to in Article 5. So that has to be read with Articles 3 and 5, as you've been taken to. We've been taken to 3 by my learned friend. Subject to subparagraph 4, an entry clearance shall only have effect as leave to enter if it complies with the requirements of this article. And at 313A, the entry clearance must be endorsed with A, the conditions to which it is subject, which is words that we respectfully rely upon. And if you then go to Article 5, and you'll see that under page 100, an entry clearance shall have effect as leave to enter subject to any conditions, being conditions, and these words, of a kind that may be imposed on leave to enter given under Section 3 of the Act, to which the entry clearance is subject and which are endorsed on it. In addition, we respectfully submit, one has to look at, and you've been taken to this, Immigration Rule 25A on the definition of entry clearance. Can I take you, I think that's now in page 770 bundle. And 25A at page 770, you've been taken to this already. An entry clearance, and we stress these words, which satisfies the requirements set out in Article 3 of the Immigration Leave to Enter and Remain Order 2000, would have effect as leave to enter the United Kingdom. The requirements are the entry clearance must specify the purpose for which the holder wishes to enter the United Kingdom and should be, in these words, endorsed with the conditions to which it is subject, or wish a statement that it has effect.
There's obviously a typo with a statement.
Yes, I'm sure that's right. With a statement that it has effect as indefinite leave to enter the United Kingdom.
Yeah.
And then it continues, the holder of such entry clearance will not require leave to have been taken to that. The source of interpretation of the entry clearance, and you've been taken to this as well, it's section 33 of the Immigration Act, which you will find in the same document.
You mean in the same bundle?
Same bundle, I'm sorry.
767.
Yes.
165.
Yeah. Thank you.
I'm
Section
sorry,
33.
yes, 767 is Scotland.
Yes. In England,
Yeah.
give me
And
one
Wales,
moment.
England and Wales.
England and Wales, yeah.
Yeah, indeed. Give me 1 second. I'll just think. 764 is where it starts for England and
Yes,
Wales.
that's right. That's
Thank you.
yeah.
And that's the source of the interpretation of entry clearance. And I think
Yeah.
it was a point that was noted yesterday, my Lord, Lord Justice Lewis, that entry clearance means a visa entry certificate
Yeah.
of or other document which, in accordance with the immigration rules, those words, taken as evidence the requisite year, evidence of a person's eligibility, though not a British citizen, for entry into the United Kingdom. It doesn't include a work permit. And in our respectful submission, in the construction and the understanding of FP2, that must be read in line with paragraph 25A that we've gone to. We know, and it's been confirmed by my learned friend, that the appellant made clear that the respondent was not issued with a granting letter specifying the conditions of her leave in the United Kingdom, or the only condition, although the only condition which we characterise as limitation rather than condition, but that's how my learned friend put it, was the length of her stay in the United Kingdom whilst holding an EU family permit, and we know that there's a 6-month period, and the basis upon which it was granted, which was, of course, as a dependent parent. But one has to, in our respectful submission, give credit and recognise paragraph 25A referring to the purpose of entry clearance. And in our case, that's how we say FP2 comes into play, and that we respectfully submit that the upper tribunal's interpretation of these two appendices is consistent with the 2000 order. And I shall go briefly to the upper tribunal's decision in relation to.
But it's a different purpose. The purpose of the provisions in the appendix is one thing. The purpose that has to be endorsed on the entry clearance is another. It's perfectly clear a purpose was endorsed on the entry clearance. It was to join Ms. I'm not interpreting to join her daughter-in-law.
Yes.
That I just don't quite see where you're going with this point based on what has to be endorsed on the entry clearance.
We respectfully submit that you in determining the purpose of entry clearance, it has to be one that's consistent with what paragraph 25A requires.
25A says you must endorse the purpose, and the purpose is to join LM Pregentia. That's one reason. The next question is, if you're right that the 6 month is not a condition, but is a definition of validity, there are no conditions. endorsed on this. So is your submission that it cannot be an entry clearance if there are no conditions in existence and are not endorsed?
I didn't understand that to be your submission. If it is, it's not one that's been made before.
I'm not sure
No,
quite.
we're not saying that. Just give me one moment to
Ah,
turn my
right,
back.
okay.
Right?
Yes, that's what I think.
Yes, right.
It's not what we're not departing from our position. What we respectfully submit is that the upper tribunal's understanding of the purpose behind FP2 is reflected in the way that they analyse the matter, and I was hoping to go really to the to what they said about
Well,
2000.
when you're ready, but that's probably, is that a good moment to
Yes,
go
it
to?
probably is.
Yes,
Thank you.
thank you.
So if we can go then, please, to it's in bundle 2. The decision starts at 57. But we're going to ask really to look really from paragraph 14 onwards at page 60, and specifically going to focus for these points on paragraph 18 in due course. Paragraph, I know the court will have been looked at this with care, and I don't want to.
Obviously just don't read that for the sake of it, but this is the decision under challenge, so don't be coy about
Thank you, my lord.
telling us what it
So
says.
it starts paragraph 14. In our judgment, the essential question concerns the operative basis upon which the appellant was admitted at the border. We know the situation about when her passport was stamped. And then they analysed what the First Tier Tribunal judge found, that the appellant's prior entry clearance under Appendix EUFP converted into leave to enter under Appendix EUFP. If then the judge was right to conclude she hadn't been granted to leave.
Yeah. Well, that sets up what the two positions
It
are.
sets up the two positions, exactly. And then at paragraph 15, they say, and really there's no issue between the parties in relation to the Mahad point, so I'm not going to spend time on that in relation to everyone recognises that Mahad determines the question of interpretation of the rules. Importantly, they found that we consider the two appendices should be read together, considering the stated purpose and role of each, and we do rely upon the point that we've made numerous times in relation to the purposive issue. The chronology of decisions under the two appendices appears to us, and then they set out how they interpreted it. The applicant applies for entry clearance under EUFP. If it succeeds, they're granted entry clearance under that, and once they present at the border, they're granted leave to enter. And then the question is...
and again, that's really setting up the essentials.
It sets up, exactly. So this is paragraph 16 is really where the decision starts.
Yes.
We find that the operative part of the rules under which leave to enter is granted to the holder of an EUSS family permit granted under Appendix EUFP is Appendix EU. The focus of EUFP is the granting of entry clearance, and then they refer back to FP1, which we've spent some time on.
Yeah.
By contrast, Appendix EU makes detailed provisions for leave to enter and remain to be granted to the beneficiaries, and then they reference EU1. And then EU14, again, you've been taken to that at some length, addressing leave to enter for dependent parents. And then they say this, Appendix EUFP, by contrast, makes no provision for the granting of leave to enter and expressly states that its purpose is to operate in tandem with Appendix EU. And that, we respectfully submit, shows the connection, the nexus, as the upper tribunal found in relation to FP2. They then look at why they essentially challenged the First Tier Tribunal's decision at paragraph 17 and make reference to reading into Appendix EUFP wording that is not there. And then in paragraph 18, they say this, which we respectfully submit is important. It is nothing to the point that the 2000 order makes provision for entry clearance to have effect as leave to enter. This is of course correct, but the 2000 order does not specify the provisions of the immigration rules under which entry clearance shall have effect as leave to enter or otherwise descend into that level of detail. The respondent, we don't need to take the observation at the end of paragraph 18 in terms of what my learned friend says in relation to
No, well,
how
that's
the case
sensible of you. Yeah.
and we simply don't. It wasn't helpful for the tribunal.
We're all agreed, and Ms. Smythe has made it clear it wasn't helpful, but we've got to decide what the right answer
Correct.
is.
So I don't say anything more about that.
Thank you.
The respondent respectfully submits that it is necessary to consider the purpose of the relevant appendix under the immigration rules in the circumstances, but we challenge respectfully the appellant's submission that the 2000 order simply needed to confer leave to enter, because if that was right, we respectfully submit that the need for the family permit under Appendix EU FP and its operation for the purposes of obtaining further leave under Appendix EU would be OTOs. We say, with reference to section 4.3b of the 2000 order, can I ask you just briefly to return to the authorities bundle? I would ask my lords please to park in relation to bundle 2, because I'm going to hopefully complete the point in relation to paragraph 20 shortly.
Yes,
but can I take you please to pages 96 to 97 of the bundle? And what we say there is at section 4.3b. The respondent, with reference to section 4.3b of that 2000 order, the respondent was granted entry clearance that was converted.
Sorry, can we just look at 4.3b?
Yes.
So I haven't looked at this before.
So it's section 4 starts at page 95.
Right.
And 3b is at the top of 97.
Well, it's not at the top of
Well,
97.
bottom of 96
Oh,
is where 3 starts.
sorry, I was looking at 3. I was looking at 3b, which is you
It is
mean
a
3
little confusing, my lord. Yes.
Sorry.
Not at all. So perhaps it's
Yeah.
right to say, I know my learned friend took you to this, but perhaps we should look first just at section 4.1 itself. So you've got a visit visa, unless endorsed with a statement to have effect, a single entry visa shall have effect as leave to enter the United Kingdom on unlimited number of occasions. That's the point really that has been taken, it's been clarified this morning in relation to, and then 4.2, what happens each time that the holder arrives in the United Kingdom, and how long the leave is, limited period, 6 months, or remaining period of validity if less than 6 months. That's 4.2. If you 4.2. If you then turn, please, to little 3 at the bottom of 96. In the case of any form of entry clearance to which this paragraph applies, it shall have effect as leave to enter the United Kingdom on one occasion during its period of validity, and on arrival, the holder shall be treated for the purpose of the Immigration Act having been granted before arrival leave to enter the United Kingdom. Then there's reference to A in the case of entry clearance, which is endorsed with the statement have to effect indefinite leave, or, and this is B, in the case of an entry clearance which is endorsed with conditions for a limited period, being the period beginning on the date on which the holder arrives in the United Kingdom and ending on the date of expiry of the entry clearance. We respectfully submit that the operative basis for the respondent's grant to leave to enter is Appendix EU, and that's obviously something that the court will have to determine.
What does the word "it" mean? Though in the beginning of line 1 of 3, in the case of any form of entry clearance, it shall have effect. It's the entry clearance document that has effect. So you've got a document which is an entry clearance, and it is the document that gives leave to enter. in the cases defined. Do you need anything more than the entry clearance?
I'm sorry, I'm not with my lord.
In the case of any form of entry clearance to which this paragraph applies,
Yes.
it shall have effect as leave to enter. So the thing that has effect as leave to enter, the document that you wave around, is the family permit. Why do you need to go to any other rule?
To put it another way, what the upper tribunal is saying and what you are saying is that the Appendix EU is the operative basis of leave to enter. But what my lord is pointing out to you is that under the 2000 regs, the entry clearance, which in this case was granted under FP, or takes the form of family permit, is the operative basis.
Yes.
That's all you need.
Yes.
So this search for under which appendix was the entry clearance granted, or sorry, was the leave to enter granted, is not an inquiry you need to make. Once you've been granted entry clearance, that's it.
Yes, my lord, I'm grateful that it's.
But that is the point. Well, but it's a point against you unless.
We respectfully submit that the reference that the appellant makes in a number of instances to this appendix within Appendix EU FP is not inconsistent, and we recognise that they say it a number of times, and it's there in relation to FP in a number of occasions. It's not inconsistent with the upper tribunal reasoning in relation to the respondent's entry clearance becoming leave to enter, because we respectfully submit that the respondent applying and obtaining status as a dependent parent as a result of the application in June of 2021 falls within the ambit of somebody already holding status under the EUSS as a dependent parent, and that she had, the appellant was operating a concept of assumed dependency until 30th of June 2021, which, as the upper tribunal found, held was a domestic construction and an introduction by the appellant to process a particular cohort of dependent parent applications. And you can see that, I think, at paragraph, you can see that towards the end of the decision at paragraph 20, 19 and 20. So we respectfully submit that, and indeed, that's really, it's of some significance to note when the upper tribunal refused permission to grant permission, there's a specific reference to the reasoning behind the decision that the upper tribunal came to. And can I take you to that, please, briefly? At it's page 53. Page 53. Starts at 53. Can I take you to 54 on subparagraph 3? Upper Tribunal Judge Stephen Smith said, the concept of assumed dependency is not found anywhere in the Withdrawal Agreement. It's an entirely domestic construct pursuant to which the Secretary of State chose to make more generous provision than that required by the UK's obligations under the Withdrawal Agreement. As the application for permission to appeal states at paragraph 7, the settlement scheme rules changed over time as they're entitled to do. If the Secretary of State considers this aspect of the immigration rules lacks clarity, it remains open to her to make the necessary amendments to put the point beyond doubt, as recognised by the Browns. And of course, we do know that changes were made subsequently, as my learned friend has already addressed you in relation to that. And we respectfully submit that if the immigration rules are clear as in the requirement to prove dependency when applying Appendix EU, it will be unnecessary to amend the immigration rules, which we know were amended on the 7th of September 2023. making this clear. And I don't know if my lords want me to go to the changes which happened subsequently on the 7th of September. I think you were taken to those. That if the position was clear and understood, there would be no need to amend those immigration rules. So we respectfully submit that it is noticeable in the context of an issue of lack of clarity. Can I take my lords, please, to I think we had further larger copies, but I think at hearing bundle 2, you have at pages 89 to 92.
Yes, well, those are the ones I've marked up, so let's stick with those. Yeah.
Thank you. The appellant's position in relation to the interpretation and operation of these appendices, we know, has changed since May 2021, when the EU Resolution Centre offered an interpretation and operation of assumed dependency after 30th of June 2021. And you have that there. And in accordance with the response from the EU Resolution Centre, it states at page 90, sorry, at page, yes, it says at 89, you've got there a reference to FP2 at the bottom. You can see that at 89. FP2, this appendix has effect on the wording of FP2. And then at page 90, you'll note what's below the 2 screenshots. The above 2 screenshots, middle of the page, page 90, indicate that Appendix EU and Appendix EU FP, as well as the caseworker's guidance, should be considered together. And then you'll see this, and it's towards the bottom. Do you have the section, the sentence that comes therefore towards the bottom, page 90?
Yes, therefore, as an EUSF. Yeah.
It's classed as LTE. As long as the applicant entered the UK whilst that the FP was still valid. Even this is after 1st July 2021 and applied as a JFM within 90 days of arriving in the UK, they would not be required to then evidence dependency, which we respectfully submit further demonstrates a lack of clarity in relation to the requirements. And there has been my lords have been provided with a huge amount of material over the last 24 hours or so in relation to this question, in relation to these 2 appendices. And what is absolutely clear is that lack of clarity is reflected, not simply in terms of cases appellants say make no point about it, but how this case was dealt with in the lower court. But the lack of clarity is reflected in the interpretation of the operation provided by the EU Resolution Centre.
Can I just understand this, mission? We're dealing with the proper meaning of the immigration rules and the appendix.
Yes.
Is this screenshot? This is an email from somebody in the department to the Resolution Centre.
Yes.
And if the Appellate Tribunal were wrong, and if the appeals then whoever gave that advice from behalf of the Home Office gave wrong advice.
Yes.
If you're right and the Appellate was right, the advice was correct. But how can what somebody in the Home Office, without any disrespect to anyone in the Home Office, how can what one person in the Home Office thinks the rules mean be relevant to what, as a matter of construction, the rules mean?
My lord, we don't make the point that this somehow ties the Home Office to a position that they previously... I can't make that submission. The submission is that this is complex. There's a lack of clarity. Even if you're against us in relation to FP2, and even if the court is against us on the primary question about whether there's a nexus between the 2 appendices, this lack of clarity was caused by the legislation that was introduced in relation.
Well, but so what? We've got to decide what it means. You might have a point about costs, but it doesn't can't affect the substance of the decision.
I don't advance the point as
I
a
see. Well,
substantive.
you're just getting off your chest.
I'm that's perhaps a little strong. I think what I'm trying to say is that there were clearly ways, and the whether it's a change in the law or whether it's a clarification of the law as reflected in the statement of changes which came later, there was a crying need for clarification as to the connection or otherwise of the two appendices, and one can readily understand, in our respect for submission, how it was that respondent came to be in the position that she did in relation to the applications that she made in this context, and the one doesn't know, of course, the advice that she would have received, but one can readily understand the concerns in relation to how the legislation sets out the position in our respect for submission. But of course, I don't say
No.
that
Very
determines
good. Well,
the
you've
question.
said what you have to say about that. Where do we go now on substance? Are we nearly there?
My lord, I think it is. I am nearly there, because when one gets beyond the important assistance that you've received from my learned friend in relation to the many guiding aspects in terms of the legislation and the statutory instruments and so on, the point is, as my learned think very fairly to her said at the outset, is quite a narrow one. And so can I complete the point by returning, as I said I would, to paragraph 20 of the judgment of
Yes.
the Upper Tribunal. Noting what they have said in relation to paragraphs 15, 16 and 18,
Yes.
at paragraph 20, the paragraph 19 I should just pause because that is a significant point in relation to paragraph C in the definition of dependent parent. My lords will have had it fresh in your memories what my learned friend has said about that and the court's observations that the way the Upper Tribunal deals with subparagraph C avoids the consequence of an otious, I'm not sure quite what the noun is, otiousness of the
Redundancy would do.
sorry?
Redundancy.
Thank you, my lord, of dependent parent. They make that point, and they say in the middle of 17, we reject Mr. Lindsay's submissions that the inclusion of paragraph C was a matter of good drafting to cater for possible future changes in the rules. Appendices EU and EUFB do not appear to be drafted with future, even present clarity in mind. I've really made my points about clarity. That appears to be what the Upper Tribunal considered. Still less do we accept that we can impute to the rules an intention to make provision that beats the air. We prefer the construction we have set out above, which gives the rules their ordinary meaning when examined by reference to chronology. And we also observe there's a coherence between the assumed dependency from which an applicant to this appellant's position would benefit and the assumed dependence from which he would already benefit, having applied for the family permit by 30th of June 2021. So they are looking to avoid paragraph C being regarded as OTOs in the way that they make their findings. And then at paragraph 20, they conclude, drawing this analysis together, we find that where an individual has been granted entry clearance as a dependent parent and subsequently granted limited leave to enter at the border in that capacity, the operative basis upon which the individual was granted leave to enter at the border is to be found within Appendix EU. It follows that such an applicant would already have been granted leave as a dependent parent under Appendix EU and therefore wouldn't be subject to the requirement to establish dependency. So we respectfully submit that the Upper Tribunal, having carried out that reasoning, having noted the 2000 order, having taken into account the immigration rules, having also considered the two EU schemes, the two separate EU appendices, and noting the significance of what they regard as important of FP2, understanding the purpose behind FP2, and also recognising what they would find was a nexus between the two appendices, albeit we take the point in relation to this, the reference to this appendix, that FP2 helps the interplay between the two appendices which are connected. And in our respectful submission, the Upper Tribunal came to the right decision in the way that they did for the reasons that we've sought to address before my lords. I haven't said anything about, and I don't know, not sure what it really is for me to say anything about the subsidiary submissions in relation to the air submissions.
Yes, I was just thinking about that. Is this the position you have in your submissions in response, basically adopted what the intervener says? If we allow Ms. Knight to develop those submissions as a matter of substance, I think that your primary position is simply you will adopt what she says. If we don't allow her to raise them for the reasons advanced by the Secretary of State, the same reasons would prevent you raising them as well. So I think you're safe, really. We will have to hear shortly from Ms. Knight and decide whether we are going to allow these submissions to be advanced. If we're not, then you've got nothing more to say. If we are, then of course, if she gets something wrong or you want to help her out, you can say something at the end of her submissions, but they're not something you were planning to develop separately and independently.
Our primary submissions really are everything that I've addressed.
Yes. Well, that seems a sensible way of dealing with it, if that's all right. If we do allow them to be pursued, and if you then want to add something.
Yes, I recognise we haven't
do that
served
at that
the
stage.
respondent's notice.
No, well, I don't know whether any point would be taken on that, but let's see if we get there.
Can I just turn my back to check I've said everything that I need to say?
Of course.
Thank you very much. I'm grateful to those behind me, my learned juniors. I think I just need one point to address my Lord Justice Lewis's observation that then, my Lord, then Lord Justice Underwood, you said, of course, this is arguably a point against you because of what's contained within the order. We respectfully submit that this is why FP2 is of significance, because you can't ignore it's there, because it's not normally open to go to deal with the thing beyond what's contained within the rules. But here we have an express provision which caters for the situation which would otherwise not exist. So whilst as a general point of statutory construction, of course, we accept it wouldn't normally be necessary to go further. Here, there is assistance in relation to specific provision in relation to FP2, which we respectfully submit caters for exactly this situation and therefore has validity and significance, which takes it outside what would otherwise normally have to accept be the end of the matter. But because of the presence and significance we respectfully submit of FP2, that means that has validity.
It would be a slightly unusual position to have the rules, which are not in the strict sense legislation, though I know they have a curious quasi-legislative status, trumping what was said in an order which was formal secondary legislation.
There appears to be a conflict. Of course, I take my Lord's point that I don't think we can overplay this point, but we do respectfully submit that the presence and existence of FP2 means that it's not simply a matter of saying, because the word it is there in relation to...
The other oddity you've got, sorry, is the appendix FP is an appendix. What is an appendix to? The rules. The rules include Rule 25A. The rules themselves, if you look at the rules without going to the order, say the same thing in 25A, broadly, as the order says. So you have to ignore parts of the rules and the order.
Well, the consequence would be is if my Lord were to conclude, if my lords were to conclude that what the wording of section 25A in relation to it prevails, that adds to our point that FP2 would then be regarded as OTOs, and one has to question.
FP2 is your case, really, yeah.
Yeah, and you simply cannot ignore FP2 in my respectful submission, our respectful submission. So I hope that these deals with the point in terms of how we present on that point. May I thank my lords?
Thank you very much. It's been very succinct. Smith, do you need to add anything?
Very, very quickly, two points of correction, very minor. First, there was no withdrawal agreement bill which was ever introduced under the May government, but all the work...
These are corrections of yourself?
Yes, it's a correction of myself, not Mr Metzer, but all the work was going on as I submitted. The second matter is just in response to the example that my Lord Justice Lewis gave with the person who had their biometric residence permit and then left. Just to confirm that that person, because they had at one point before the end of the transition period been resident here, they would be treated as somebody resident before the end of the transition period, even though they'd left. And so for that person, in those circumstances, they could make an application under the EU settlement scheme and wouldn't need to show dependency because they're in that particular cohort. So that's the answer to that. And then three very brief points. I hadn't addressed the explanatory memorandum which was handed up. I say it supports my case. We accept there is of course a nexus. I've accepted that. I've said, well, yes, it helps you get here and then make the application that you need to, but it certainly doesn't help prove the point of law.
It brings out one point that I hadn't really spotted before. That it's perfectly possible that someone could come over on a family permit simply to see their family, never intending to apply for more than 6 months.
Yes.
It would just be an alternative to a visit visa. I mean,
Yes.
no matter which way you did it, but
Yes, that was my point about they may
Yes.
just come, they might want to do some sightseeing, but yes, they'd probably
Yes.
want to see their family. But yes, that rather supports my case.
Yes, right.
That, and I've made my submissions, I won't
Yeah.
repeat that. The second point in relation to paragraph 18 of the Upper Tribunal, the court's observations to my learned friend essentially preempt our position on that, which is set out in a skeleton, which is you don't need to start getting into the immigration rules because the leave to enter order tells you everything that you need. That's our answer on that. And then the third point, we've referred in our skeleton and our response to the amendments to the immigration rules. I didn't take the court to those in the interest of time because, of course, I say the fact that they were amended, and we say in our skeleton only as a belt and braces, really, doesn't help the court. And of course, the Secretary of State doesn't want to wait until we get to the Court of Appeal, wait to see what the court says. The Secretary of State clearly thinks his interpretation is right, which is why I'm arguing what I'm arguing, but it was done for that reason.
You might lose, and if you do lose,
Yes.
at least you've got these in place.
Yes, exactly. It's belt and braces. But I wanted to say that because I hadn't taken the court.
no,
in,
I
but
think we
wasn't-
all assumed that. and
Yes, they're there. They're in the bundle and they're covered in the note. That's all I have to say in reply.
Can I just ask you one technical point, which has bothered me, I forgot to raise with you before, it could not be more trivial. In ordinary statutory drafting, if you have appendices, there will be, schedules, I suppose, not quite the same thing, but there will be a provision in the main rules saying Appendix X will take effect. And indeed, I think pretty sure that's how it was done with Appendix FM. Are there somewhere some rules, is that in the rules saying Appendix EU shall take effect? Or
It's set out in the implementation section of the statement of changes.
Yes, I think
I'm
that's what
told.
you do now. You simply say in the statement of change, this is an appendix to the rules.
Yes, and then it has effect
I
in
see.
that way. But I can tell the court if it would help precisely which statement of changes and so on.
no, don't worry. It's just normally if I was drafting something saying, let's say in the case of a Schedule X, which takes effect by section such and such, I can't say Appendix EU, which takes effect by Rule 426E. No. Okay, that's fine. I said it was a small point.
Thank you, my lord. I don't have anything else to say in reply.
Yes. Just one moment. Yes, Ms. Knight. Well, we have warned you that we see some difficulties, and we needn't spell them out. They are the ones the Secretary of State's response.
Yes.
And now is your chance to show why those difficulties are not real or not such as to stop you advancing the substantive points you want to advance.
Yes, thank you, my lords. I just wanted to deal with those, there's 5 just brief headings, which is one, what was the ambit of the intervention that we proposed? What was the format it was presented to this court? What was the order, what was the responses of the parties?
So ambit, format, responses.
Responses of the parties, and the order of Lady Justice Lang in relation to the application.
Yeah, we've got 4 therefore.
And
the 5th.
And so I'll just deal with those 4 points first,
Yes, okay, fine.
if I may. So the application was, the ambit of the intervention was foreshadowed in our application notice, which is, before the application notice, I should say, in the correspondence with the parties, and you have that in the bundle 3.
Yes.
Which is the letter, the application notice was later filed on the 6th of March.
Yes.
Sealed on the 6th of March.
Yes.
But it was within that application notice filed by Herbert Smith Freehill was a letter to the Government Legal Department dated the 19th of February. And that letter is at page 14
Yes.
of that bundle. So the application submissions that shortly at paragraph 2, page 2, sorry, within the application notice itself, and then the letter from Herbert Smith. And at paragraph 6.
Well, would you read 5 first?
Yes, we accept this. The case raises an important point about the principles of the interpretation of the Appendix EU FP and the Appendix EU of the immigration rules, as indicated obviously by the order granting permission, as well as the obligations under the Withdrawal Agreement. And we say in our submissions, in our letter, paragraph 6, that we will address the following issues: the proposed addressing specifically the appellant, Secretary of State submission, that the interpretation of Appendix EU is in line with the Withdrawal Agreement.
So the ref 42, that's a reference to their
To
skeleton.
the Secretary of State skeleton.
Yeah.
And the second point is that the Air Centre will consider the material provisions of Appendix EU and the Withdrawal Agreement, including the requirement to construe any provisions which implement EU law in line with general principles of EU law, and in particular the submissions will focus on the general principle of equal treatment, which are material to the present appeal and not something addressed by the respective parties. So we accept that we had said in the application that there is an issue, which is an issue of construction, which goes directly to the question of the withdrawal agreement. We had to obviously say that it hadn't been addressed by either of the parties. And it was on that basis then that the following correspondence, we don't necessarily need to turn it up, but in summary terms, the parties didn't object as long as they had the opportunity to respond. And then what was also, for these purposes, included was that the proposed submissions, which we've now had some minor corrections to, hopefully minor, but the proposed submissions were included within the application notice. So at page 34, and critically before the order Lady Justice Lang granting permission, those proposed submissions, we called ourselves proposed submissions for the proposed intervention, are at page 34 of bundle 3. So it was clear to the court, we hope, that what we were going to say and how we were, in quite detailed terms, going to say that. And that was obviously because of the timing. We recognised that we were coming up close to the appeal and we needed not to cause any party prejudice by that process. So it's for those reasons that we say we set out our intervention, proposed intervention, and just in the format it was put at that time at page 34. The appeal raises important questions concerning material provisions of the EU settlement scheme Appendix EU and Appendix FP, and the agreement on withdrawal, and we specifically, we say in these submissions, the key legal provisions and how they should be addressed. Paragraph 2, whether it's lawful for the UK to operate a system for issuing documentation under Article 18 of the Withdrawal Agreement, which at times imposes different evidential requirements for joining and seeking to remain as the dependent parents of EU nationals. And in summary terms, of course, we've amended that summary now, particularly in light of the sort of slightly evolving picture as to how these rules operate. But the way we put it now is that the Secretary of State's decision to create a scheme joining family members. So this, the amendment.
Yes, I'm just
The
to find
amended
those. I've got those loose still.
Yes, they were.
They are only loose, aren't they? Were they put in another bundle?
They were, I think, put into the end of bundle 3.
Or were they? Okay,
No, they
well,
were. Sorry, apologies, they weren't put in the end, but they are floating loose. We do have many copies of the corporate file.
Okay, just give me a moment while I dig them out.
Ah, sorry, I've got a very lovely bound copy of them.
Well, all right, I'll have it, if only because that way it's easier to recognise with its
Indeed.
nice comb binding.
Is it indeed?
Thank you. So,
And so we
what
come
it now
to
says is,
it's paragraph 3 for these purposes. The Secretary of State's decision to create a scheme for joining family members from the 30th of June, in which he resolved from the initial evidential requirements for joining dependent parents, depending on the date of their application for pre-settled status under Appendix EU, but critically for our purposes, permitted the relaxed evidential provisions in relation to dependent parents already in the UK before the 31st of December to continue. And you will recall Ms. Smythe's submissions just at the very conclusion of her submissions, where she addresses that point, not necessarily in response to the intervention, but that is part of her case as to it's not in dispute that there are more favourable rules for dependent parents who remain who were in the UK as at the 31st of December 2020, and they still remain. Those provisions on assumed dependency still remain, so for persons who make, for example, late applications if they have good reason. So the disparity of treatment is not.
The problem I've got at the moment, as I understand what you're saying, tell me if I've got this wrong. You agree that if you look at the rules in the format that they stand at the moment, Ms. Smythe is correct in her interpretation, but you want to declare invalid or find invalid a decision to have them in those terms, which is really a judicial review, isn't it, rather than an appeal.
Well, my lord, I was conscious of the approach that my lord or the court took in Chellick, at least to consider that question. But we don't say that this is a grounds for a judicial review. Far from it. It may be for some other party to want to advance that case. We don't advance a case like that because this issue concerns an appeal brought by Ms. Rexhaj against the decision to refuse her application under Appendix EU, and she has a right to appeal that arises under the regulations, which includes, as Ms. Smythe took you to yesterday, the question of whether or not the decision is, if I could just turn that up, it's at tab 7.
where are we looking?
The authorities bundle tab 7. And it's regulation 8. There are two grounds of appeal, two sort of broad headings of appeal, if I can say that. 8.2, the first ground of appeal is that the decision breaches any right the appellant has by virtue of a chapter of this chapter titled 2 and in relation to the withdrawal agreement. And the second ground is not in accordance with the residence rules 3A regulation 8.3b, which was the one that Miss Smythe was referring you to in more detail yesterday. it's quite clear from the First Tier Tribunal's decision that the withdrawal agreement and the ambit was identified there, and the First
So
Tier.
are you relying on 8.2 or 8.3a?
We are relying on 8.2, 8.2a, which is, so rather than necessarily looking at whether the question of the issue is in accordance with the resident scheme under immigration law, which is 8.3b, the
Sorry,
ambit
would you
of,
just give me the page again?
page 141 of the authorities document.
Yeah, thank you.
The ambit of the appeal in general, so this is why we say it's not a judicial review, because what the court, or any court has to do in first terms is, with an appeal before them, is to interpret the Appendix EU in line with the withdrawal agreement.
What is the right that this appellant has under the withdrawal agreement being breached?
So the right she has is an EU law principle not to be subject to unequal treatment. That's so. In order to make good the ground, I need to build and identify the provisions in the withdrawal agreement.
I understand that, but I just want to
Yes.
be
Yes.
clear
It's
exactly
the
why
principle
you
of
say this comes within 8.2a, and it's the right.
not to be subject to unequal treatment under community law for persons who are in analogous positions, and that is family members, we say, under Article 2.2d of the Citizens' Rights Directive.
And why is that a right that she has by virtue of the withdrawal agreement?
So the rights. So if I come back to the starting point, the withdrawal agreement preserved the rights that had been that family members had under Article 2.2d of the Citizens' Rights Directive. Those were preserved in the withdrawal agreement.
Yes.
And so when
They require proof of dependency.
they required proof, they required persons to be dependent, and how that was evidenced was a question that the Secretary of State applied a relaxed provision in relation to certain periods of time. There was always a requirement to be dependent. We accept that there was a requirement to be dependent, but what we say is that the condition, the way in which that condition was met, the Secretary of State adopted a more flexible or assumed position for a certain period of time for certain categories of people. I mean, Miss Smythe and I are not in. We're not in conflict on that point. She says it in terms, and she says it was done for administrative convenience for a certain group.
Yes, but stick to the point.
And then ministers decided that they were more.
Yes, I know,
concerned with
but what's your answer to my Lord's question?
So my Lord, in relation to my Lord's question, the principle in Article 4 of the withdrawal agreement, if I can take you to that, which is at page 6 of the authorities bundle. Which relates to the methods and principles relating to the effect and implementation of this agreement. Paragraph 3 there, so it's page 6 at the bottom of the page. The provisions of this agreement referring to European law or concepts or provisions thereof shall be interpreted and applied in accordance with the methods and general principles of Union law. And then paragraph 4, the provisions of Union law shall be, or concepts of provisions shall there.
Well, that's a different point.
Yes.
But
So-
which are the provisions of this agreement referring to union law?
Well, my lord, all of the provisions that we rely on, I don't need to go through all the provisions.
Yeah,
but
which are the
we're
relevant
relying on
provisions?
Article 10, which is the personal scope.
Hang on, let's just go to
That's at
Article
page
10.
9.
Yeah.
Which again, the Secretary of State's position is that she's giving effect to Article 10 through her rules, and we say that the appellant, sorry, the respondent, Mr. Rexhaj, is entitled, as any union citizen, a family member of a union citizen, to have the personal scope interpreted as set out in Article 10.
And where is what is the provision of Article 10 which is breached?
So the Article 10,
Or to be more accurate, which requires to be interpreted in accordance with.
so Article 10, this claimant, this appellant, or this respondent comes under Article 10. Article 10 1F, sorry, 1E little Roman 2 is how the family members are defined, and she is seeking to rely on the right of entry and the right of residence that arises under the Withdrawal Agreement articles.
Which requires dependency.
We accept that, which requires dependency, and we say that she's not. There's no part of her case that says she's not dependent. She submitted to the Secretary of State that she was dependent, and for the purpose of the entry, she was assumed to be dependent. That was, according to the Secretary of State's case, a relaxation or an easement, I think the way Ms. Smythe described it, in relation to how that provision under 22D or was the Citizens' Rights Directive was applied. And for these purposes, we say we can identify after her arrival, the appellant or the respondent was not permitted the same evidential flexibility, if we can say.
But that's a matter of domestic law, because Article 38 allowed the United Kingdom to be more generous. Article 43, firstly, that's not something within the scope of Article 8 anyway, because that's Chapter 1 of Title 1, not Title 2. But secondly, you're not trying to interpret Article 10. Article 10 is clear. It does, and has always required residence, dependency
yes,
to be established. For a brief period, the government of the United Kingdom said, no, we'll assume it, rather than ask for documentary proof or whatever. And now the United Kingdom government has changed its domestic rules to say, we will require what Article 10 requires. So you're not actually trying to attack or interpret Article 10, you're really attacking a separate thing, which is the decision of the Secretary of State not to continue its discretion under Article 38 of the treaty.
Well, my lord, the discretion, such as it is, arises under Article 13 for the first point. So Article 13 set out at page 10 and 11 of the Authorities Bundle, but particularly for these purposes, Article 13(4), and that allows the host state may not impose any limitation or condition for obtaining or retaining or losing residence rights other than those. Yes, and there shall be no discretion. There shall be no discretion in applying the limitations and conditions for this title, other than in favour of the person concerned. But what we say is where the host state operates a more flexible standard in relation to the evidential requirements for meeting a condition that allows for residence provided for under the withdrawal agreement, that doesn't make it a wholly domestic arrangement. And the key point for the air centre's point of view is that in order to interpret whether the impact of that concession, if it's like, or for the Secretary of State's applying the discretion more favourably for certain groups of people, this court needs to examine the relevance of the withdrawal agreement to the impact of the Secretary of State's case, which is ending assumed dependency for one group joining family members, but not for family members who were in the UK at the time of the ending of the transition
Well,
period.
let's just see the point. We're not, we just remind ourselves at this point, arguing the substantive point. We're simply identifying what the substantive point is, which you've helpfully done. We may need to come back to it in a minute.
Yes.
How much more did you want to develop on the point about whether you should be allowed to take the point? You have said that you identified what the scope of the point is and
Yes.
why you say it is not a judicial review point, but actually arises um, uh, as part of the exercise of construing the agreement, which falls within and within the right of appeal.
I mean, the
Well,
short,
it wasn't clear to me from your headings whether or not you were going to take a point that it's too late for this objection to be run, because you wanted to take us to the responses.
yes,
and
so,
to
so
the
where I
judges.
was that the the parties were written to, they raised an objection as long as they had the appropriate opportunity to respond. They took that opportunity they said that they would take that opportunity to respond, and on that basis, Lady Justice Lang made her order.
Yes, but I know. But what are you saying is the effect of that?
Well, the effect of that is that the matter was raised with the parties. They agreed that they could deal with it. They have dealt with it, and where that leaves me is I need to respond to the summary points and the detailed points then raised by Miss Smythe in her
Yes.
submissions.
But there's a
which-
jurisdictional point, isn't there? I mean, if you're not within Regulation 8, there's no jurisdiction to have it dealt with on this appeal, whatever the Secretary of
Well,
State may have said about it.
Well, my lord, we say we are within
No,
regulation.
you do.
And
But to go back to my Lord's point, it isn't a question of what the Secretary of State did or didn't do in terms of how he said he would be prepared to deal with it. It's a jurisdictional question for the court that you've got to persuade us you're right on, isn't it?
I was really just observing the time. I just wanted to get a feeling for where you still had to go. So I think we won't probably sit much longer into the lunch break.
So yes.
And
Well, I just wanted to respond to
how much more do you need to say to meet the points taken against you? That's really what I'm saying.
Yeah, I suppose.
Right. I can take the points taken against me are subject to my Lord Justice Popplewell's point about the jurisdiction, but the points taken against me by Miss Smythe are 3 points that she sets out in her note at paragraph at page 59 of the bundle. The first point, which I can just deal with now.
Well, outside the scope of the appeal.
She says outside the scope of the appeal, and we say that it's within the scope of the appeal under Regulation 8.2. It's not necessarily clear whether the respondent Miss Rexhaj is dependent in substance, but for the purposes of the way the appellant was treated by the Secretary of State, it was assumed to be dependent, and other people who are in analogous positions to her, which are other dependent parents, we say, are treated as assumed dependents after the 30th of June. The second point that the Miss Smythe raises that the discrimination point wasn't raised below. Secretary of State could only address this fully by evidence, but we had foreshadowed the ground. We say this is actually about the interpretive obligations for the court.
But you do accept that you need evidence, and indeed you've applied to put in evidence yourself, something you never flagged up. If we're going to deal with discrimination, it's inevitable that we have to have evidence of justification. And this is the third consideration, the second appeal.
My lord, the way that I, in fact, propose to address the court is to invite the court to look at, because the court is concerned with what is the proper interpretation of Appendix EU, and because the appeal was brought by Mrs. Rexhaj on being refused on that basis, invite the court to interpret Appendix EU in line with whether it can be interpreted in line with the withdrawal agreement. And to
Yes,
bring,
but there's only a breach of the withdrawal agreement if this is discriminatory. And in order to establish whether it's discriminatory in this context, there's always got to be the opportunity to justify.
well, my lord, when this court, I mean, we've only very briefly been taken to the withdrawal, the European Union Withdrawal Act 2018. I took you this morning, I think, to Regulation 7. But 7A requires all courts, whether whether it was the upper tribunal, the First Tier Tribunal, or this court, requires all courts in a way a bit like the Human Rights Act might do, to have regard to, look at the general implementation of the withdrawal agreement, and which applies to all rights, powers, obligations that are created under the
but that-
withdrawal agreement. So,
Sorry,
I'm not sure what
But
you're
that's,
saying.
I mean, but no doubt. But if a point isn't taken below, that doesn't give you carte blanche to raise it for the first time on a second appeal in circumstances where if it had been taken below, there would have had to be a factual interpretation. And that would be just as much the case with the Human Rights Act point or any other new point as with any other new
I
point.
mean, my lord, the reason that we press this intervention, knowing that the point hadn't been taken in that way before, was because we were concerned that the court is to assist the court. We hoped, of course, that the court is concerned with to interpret the EU Appendix EU and the Appendix EUFP, and the mechanism by which the withdrawal agreement has been incorporated into domestic law is in the Withdrawal Agreement Act. And looking at the interpretive obligation that I referred to at the very just beginning of these short submissions at paragraph 4.3, which is that the court has to when interpreting those obligations, interpret them in accordance with the methods and principles of union law. And the short point that we identified, which is the reasons for which have become perhaps what I might say is even clearer from Miss Smythe in relation to there is an acceptance of a difference of treatment now between one class of person and another. And this court will at least have to, when looking at determining the appendix, the application of Appendix EU and the issues in this appeal, look at the impact of the withdrawal agreement. If the court is with Miss Smythe and the matter is going to be remitted, then it may be that the better, or perhaps I won't say better, but one way of dealing with the issues raised here is that this issue, it isn't formally remitted because you may say it's not formally before the court, but this court identify, as the court I think identified an issue in Chellick and then didn't deal with it because said it didn't arise. Here it does arise, we say, but if the appeal is going to be remitted anyway.
Well, in Chellick, one issue arose and the court said that was a judicial review issue and shouldn't have been brought.
Yeah.
And in respect to another issue, didn't arise on the fact.
But sorry, you haven't
yes.
yet got to the end of your sentence.
So
Your sentence was, if the court is with the Secretary of State,
And the
the
appeal
better, and the appeal is allowed, the better course might be what?
to identify this difference of treatment arising from the rules that we have, at least as a matter of fact, and Ms. Smythe doesn't disagree with it. Or there's a difference of application that in relation to assumed dependency for persons who are joining family members who applied before the 30th of June.
But hang on, this doesn't make any sense. If we are with the Secretary of State and the matter goes back, the big point of principle simply goes. You're simply left with a factual question of whether or not she was given a proper opportunity to show dependence in the First Tier Tribunal, and if she wasn't, whether she now can. So the way it's now or never.
Well, my lord, if on remittal, if the Secretary of State, if the court were with the Secretary of State and the matter were remitted to the tribunal, if on remittal the appellant was unable to meet those dependency evidential questions, then the question would still remain as to whether or not there would be a difference of treatment with reference to the assumed dependency provisions that applies to some people, not others. One of the ways this issue in some ways also arose in the Sadiqa case, where
Don't distract yourself. Just what is the point you're making?
So the point, if the case, I don't necessarily accept it's now or never, because if the court wants to hear the point and accepts that it has jurisdiction to hear it because it arises as a construction question in relation to whether the way in which the withdrawal agreement has been incorporated into domestic law and the difference of treatment that arises by virtue of the implementation of the operation of those different, the assumed dependency provisions, depending on whether you're EU, FP, joining family member or not, then that's a question that the court can identify as a difference of treatment. Miss Smythe's response is I can't deal with that point any further because I
So
have to.
is your point that
file
if we were to take
evidence.
the view that it's much too late to take it on a second appeal because it would require evidence, then that point would lose its force if we're sending it back for a decision to be remade de novo, on which there'll be an opportunity for everybody to put forward whatever
I mean,
evidence. Is that
it-
essentially the point you're making?
My lord, I think it is, because if I just may add one observation, Mr. Metzer's submissions were that he supported the Air Centre's intervention, the principles there, although those points weren't run by the Miss Rexhaj below. If that is the case, then we assume that Mr. Metzer won't change. That was still his position, subject to whether he needs to rely on it or not. And that's a question that may or may not arise in his appeal on remittal if the appeal were to be remitted. But that is one way of bridging the evidential gap that Miss Smythe says is a reason to not to permit this intervention to proceed.
But the right way to do that would be, I think there'd be all sorts of difficulties, but it would be for Mr. Metzer, if he wants to take the point, to apply for some sort of leave to amend on remittal, and we'd have to let him do that. And it's not for us whether he'd be allowed to do that. We couldn't give leave to amend now.
Well, my lord, but it brings us back to the core question, which Miss Smythe did address, which is her third submission. She says the withdrawal agreement. So she did address the substance of the point. She says the withdrawal agreement only brings into scope parents who are dependent, and if HR is not dependent, then the withdrawal agreement
Yes.
doesn't help her. And we have
You've said what you say about that. Yeah.
on that point. And then her final point is if there is, even if the principle of EU principle of equal treatment were engaged, it wouldn't be breached since as they were unjustified differential treatment. That's her case. So she has responded to it, although if the court's going to go down that.
Well,
route,
I
we
think
need-
let's just pause where we are.
Yes.
Her third point is effectively addressing the points of substance, but just saying that the so obvious they can be dealt with summarily. I don't think it's helpful for us to do that. Certainly at 125, we might, if we were going to allow the we allowed you to respond to that, we basically would have to consider the substance of the intervention. So the real question is whether the first two rounds, what we broadly speaking call the jurisdictional scope of the appeal ground, and the too late to allow you to raise a point because it needs evidence, or whether those are reasons for simply not allowing you to develop the substantive submissions at all. So far as that is concerned, I think we understand what you've had to say. Is there any more you want to say?
In relation to the second point about whether it's too late to raise, I just wanted to highlight to the court that in the case of Sadiqa, the case I handed up yesterday, which is a very recent case and no party has addressed it in fact in their submissions, Lord Justice Dingerman's approach was having gone through a construction of the withdrawal agreement and having gone through a construction of the rules and the Citizens' Rights Directive. His final question, which is at 85 to 88 of the judgment, was this is a case about additional family members, not under Article 3.2 like the Chelix or the scenario, so we're not concerned with that here.
You've also got Article 18 in Chapter 2 of Title 2, so it did raise the right.
Yes.
But can we not
But-
just
but-
find out what your point is first?
So the point is that Lord Justice Dingerman's having gone through the construction in relation to the appendix and in relation to the Citizens' Rights Directive. The final question he had to address, as I've reflected paragraph 85, I've had to reflect to consider.
Well, can we just read this?
Yes, I'll let
Read
my
this to
lord
ourselves.
read it, yes. It's 85 to 88. It's 85
Let us just
and
read that.
88.
85 and 88. We'll just read those. So how does that help us on the objection that this is too late because of the need for evidence to be adduced on the question of discrimination? It doesn't seem to me to go to that.
It doesn't go to the question of lateness. It goes to the question of what is the approach to the court in relation to construction. Maybe that does go to lateness, but the issue that the court has to consider is whether the provisions and the approach that Miss Smythe contends do not offend against the principle of equal treatment in community law. That's the short point, and we.
Yeah, okay, we've got that point, but I thought that was it's not really a point about. That's a point about the scope of the appeal, or the scope of the intervention, whether it's within the scope of the present appeal.
Well,
have you anything else to say on the second point? That's to say whether it's too late because of the fact that the issues would require further evidence.
Well, the Secretary of State, it was foreshadowed with the Secretary of State in the submissions quite clearly in that application of the 19th of February. Secretary of State said she could deal with it, and to the extent that she has dealt with it, Miss Smythe has dealt with it in paragraph 11 of her submissions anyway.
You need evidence. You've applied to put in evidence. Whatever anyone thought in the light of the letter or in the 4 days between the intervention and the order of the court, the reality of it is now is that both sides seem to recognise that evidence is required. And if evidence is required, and if it would be wrong for a court to decide a question without evidence, where does that leave us?
My Lord, I think that if that leaves the court with, if determining a question of interpretation, at least to identify, this is what the Air Centre invites the court to do, that there is a question which might arise in another appeal if it doesn't arise on remittal in this appeal, depending on how Mr. Metzer chooses and his client, more importantly, chooses to conduct the case. But to simply determine this appeal without recognising that there is an issue about the construction of the withdrawal agreement based on the very, it's a case that affects many other appeals that are in the appeal system.
Just get to the point, yes.
And so that's why we say it's important.
You're basically what you're saying is, even if we don't feel able to take the point, we should say something in our judgment to the effect that there is a point here that it will have to be taken either at a later stage in these proceedings, if allowed, or in some other case.
Yeah.
That seems rather odd in circumstances where the rules have changed anyway. There would have to be a challenge to those rules.
Well, my lord, we say that the rule, I think as Miss Smythe accepted, still permits a person who's in the UK to make a late application.
Anyway, that's the course you're invited, it's your fallback position is if we can't deal with it now, we should say something to flag it up.
And this is, and the importance of that is that we say this is not and can't be read as a purely domestic scheme, which is why the interpretation of the withdrawal.
Well, you've said that already.
And is important. So
yes, you've said that already. Right. Anything else you need to say on the question of whether you should be allowed to take the points at all?
Apologies, maybe it's just that. Just the only point to raise in response to the scope of the appeal point and the purely domestic scheme point was just for the court's reference, if we're going to note that there's an issue to be identified going forwards in another appeal or otherwise, is the case of CG, which is at paragraph 84, and the reference for that is at tab 20 of the authorities bundle. Where
we'll look at that over the adjournment.
That is also covered in our written submissions to the court.
Paragraph 84.
Is it 84? Paragraph 84 and 88. So even if there's an underlying domestic scheme, it doesn't necessarily mean that the rights of the withdrawal agreement are not engaged.
And you've had 3/4 of an hour to address the question whether you should be allowed to make oral submissions of 30 minutes. But I don't.
Well, my lord, I'm grateful for the latitude. In our defence, we'd say that the case has evolved somewhat over the last 24 hours, not for anyone's fault, but
very well. We'll come back at 2:15.